Uh, May it please, Your Lordship. Your Lordship, with regard to item number 25, 26, and 27, these are all connected matters. I'm appearing on behalf of respondent number 4 and 5. I pray that this matter be adjourned because I need to file an additional affidavit in this matter. I've taken the consent of the writ petitioner. 25, 26, 27.
Yes, sir. Yes, sir. I'm appearing on behalf of MS N Haveli, Your Lordship. S.K. Saha, Your Lordship. Shaha. Yes, Your Lordship. MS N Haveli.
And how earlier?
Yes, Your Lordship.
D. Senapati. 4 and 5. Yes, sir. Your Lordship, we have a senior counsel, Mr.
Lordship,
D.
this
Satya,
is,
appearing.
can it be on 15th of September, Your Lordship? Fifteenth of September, Lordship. Of September, Lordship. Yes, Your Lordship.
This is with regard to a termination that has been resorted. Then they are basically seeking a compensation as their assets have been taken over by the government.
Deeply, Your Lordship.
15.
15.
Much.
Maybe Lordship. Lordship, I have to mention for listing of a case today for withdrawal. Listing of a AB for withdrawal. Yes, withdrawal today. Yes, it is already listed. It is in the file. Yes, listed earlier before. So I want to withdraw the AB.
Your Honor, I beg to mention item number 24. I'm for the petitioner on behalf of the arts owner. Item number 24. Yeah. 24. Oh, yeah. Petitioner on behalf of the arts owner. Yeah, both the party respondent. Yeah, I have already informed to him. Yeah. But arts owner, the name is Kipat Tagar, K Tagar. Matter, Your Honor, matter may be released after summer vacation. No. Actually, Your Honor, both the party are trying to settlement outside the court. Yeah, that's why.
May I, Your Lordship? Your Lordship, I beg to mention item number 21. 21 on behalf of K. Tama, Your Lordship. Yes, Your Lordship. Your Lordship, on the last occasion, TCR was called for, and as per the office note, TCR has been received on 29/5. So, Your Lordship, join humbly, but we are submitting that matter may be fixed for admission hearing. Admission hearing, Your Lordship. Your Lordship, since K. Tama is appointed as legal aid counsel for this case, Your Lordship. Yes, sir. No, I will be here, Your Lordship. Okay, Your Lordship. Okay, Your Lordship.
Yes, Your Lordship. Yes. Him. Well, application stands disposed of.
May I please call?
Yes.
My lord, this is a subsequent bail application. In this case, my lord, the bail application was rejected on 29/5/2025 by the Section Judge Alok. So my only limited ground is that the grounds of arrest, which ought to have been given to me as required under Article 22, has not been complied with. That is my only ground in this case.
Okay, that was not considered by.
Yes. No, well, that ground was not raised, in fact. On merit, the bail application was rejected.
Yes, sir. That is why on merit it was
Rejected.
disposed
Yes, madam.
recently.
Yes.
And what is the new ground I am supposed to ask?
Now, my new ground is that the grounds of arrest, which is required to be given to me, has not been furnished to me.
So then.
Your Lordship may call for the scan copy of the record.
Can you correct it? Charge sheet already filed.
Charge sheet filed.
Ask Mr. J.C. Land counsel for the petitioner. This is an application filed under section 483 of the BNSS 2023, praying for release of the accused in connection with Tato Police Station case number 01/2025 under section 65 within bracket 1/351 within bracket 3 of BNS read with section 4/6 of POCSO Act. So, call for the scanned copy of the trial court record, issue notice since Miss. You have included the
Yes, Your Lordship.
Informant and the
since Miss Jeannie, then additional PP appear on behalf of the state. No formal notice need be issued to the said respondent. The petitioner shall take steps upon the respondent number 2 and 3 by a registered post with AD as well as by usual process within a week from today. Start. List this matter.
well, through the office of the PP. This
Through the-
matter of POCSO.
okay. Then through the office of the PP. Okay, then to be listed after Mr.
My lord, at least if my lord, it's matter of my right, my lord.
2 weeks.
If this matter can be taken up on Monday,
No, Your Lordship, the
Yes,
notice,
this-
notice,
I
Will
will
the
serve the
notice-
notice, my lord, on the next date. If the notice is not served, my lord, I'll take some time for that. But since it's a matter of my right, my lord, the grounds of arrest which is not been
How
furnished to
much
me.
time it will take?
because we'll have to serve the notice to our office. First, they'll have to take steps, Your Lordship. Then we'll we intimate to the.
At least 10
IO.
days is
We
required.
will do it
At
in
least 10
in
days.
2 working days, my lord. We will,
10 days at least.
on Monday, my lord.
Then steps within 3 days, or
Right.
2 days, steps within 2 days, Then it will be listed after 10 days.
10 days, Your Lordship.
When it will be?
On 26th, Your Lordship.
Okay. Listed again on 26. Okay.
Obli-
Deeply open.
Yes. Yes.
Where?
Hmm.
This is against the impugn cover decision, impugn conditional cover decision. My lord. First, very village authority. My lord. My lord, what happened in this case? My lord? This complainant, my lord, respondent, my lord, has filed a complaint, my lord, before the village authority, my lord, Boeing.
Just a minute. Huh? Respondent lodge complaint.
Yes,
Let us see the complaint.
complaint is not here, my lord.
Then
Only the cover decision is here, my lord.
where is the decision?
Page 22, my lord. The translated copy is at page 23.
For how many occasions the petitioner was issued notice? No, issued notice? How many times?
Well, as per this cover decision, my lord, four times, my lord.
Okay, this is before the,
Village authority, customary court.
okay. Four times. Okay.
Yes, my lord. This is a one-page judgment, my lord, of the
Hmm?
one-page judgment of the village authority, my lord. Now, in para 4, your honor, may kindly, your lordship, may kindly see.
Just a minute, yeah.
Yes, my lord.
Person has filed its proceeding. Okay, on ex parte proceeding
Yes,
and then heard one party.
yes, my lord.
Respondent is Tasung family.
Yes, my lord.
Okay. Respondent is the complainant.
Yes, my lord. So as per this Kebab decision of para 4, my lord,
Yes.
I was given 15 days time to recall the Kebab.
Hmm?
I was given 15 days time to recall the Kebab, para 4, my lord. This is a conditional Kebab decision, my lord.
Okay.
Yes, my lord. Now, my lord, what happened? I filed an application, my lord. On 28 to 20. This cover decision is of 19 to 2021. Cover decision, my lord.
Yes, 19-2.
Yes.
Yes.
And page 25, my lord, I filed a complaint to nullify the cover
Just a
decision. my lord.
minute. What is page para 5?
Para-
Okay. Page 25. What is this?
This is my complaint, my lord,
Why?
for nullifying the cover decision, my lord.
That's called complaint.
Yes, my lord. On 28 to 2020, that is on the 10th day, my lord.
Translation. 26. Okay, this was decided by how many GB? 2.
My lord, 1 GB.
Only one.
Yes, my lord. HGB. Going, my lord.
No, no, So what is this without the court order of the case?
My lord.
What is the allegation here?
My lord, here, oh, that page 25, my lord.
Hmm.
Page 25, yes, my lord. My lord, firstly, my lord, page 23 is my case, my lord. Para 4, my lord. Within 15 days, I have the liberty to
Yes,
recall
yes,
the cover.
yes,
Yes, my lord.
yes.
Now, page 25, my lord. In page 25, I have filed a complaint for setting aside the cover decision. Now, the translated copy would be at page 26, my lord.
Yes. What?
May I? Yes, my lord. By this note letter, I am informed you that Tamut Tosang has, without any authority and right, has earth cutting at my Kemi Among land.
Okay, that is
So
fine.
that
but
my wife was
come
those
come
applied.
down.
Sir.
So therefore,
Therefore, you quash and set aside the ex parte order passed by you. I will wait for your reply. My lord. Now, my lord, the language used by the that person, my lord, may be different, my lord, but it amounts to recalling of Kawa because, my lord, here he is praying for nullifying the Kawa decision, my lord.
so the what we want to indicate that therefore without the court order.
Therefore, without the court order, my lord, because what happened, my lord, earlier also this person, my lord, respondent herein, has tried to encroach over my land and made some earth cutting, my lord, for which this wife of the appellant, my lord, this petitioner, my lord, has filed a complaint before the police station Pasigat, which was a case was also registered as Pasigat PS case number 299.
The land was under whose possession at the time?
Land was in my possession, my lord. So he has been encroaching
the
over my land.
respondent in
Yes.
whose favor the GB decided,
Yes, my lord.
he started art cutting.
Yes.
Then you lodge
my lord.
FIR.
Yes, my lord, my lord. What happened, my lord? This criminal case, my lord, was registered before the initiation of this cover proceedings, my lord.
Kaba was decided on
2020, my lord.
19 to 2020.
Yes, my lord. This is of
And
2018, my
the
lord.
FIR was lodged
2018, my lord. GR case number 296 of 18, my lord. Pasigat PS case number so and so 299 of 18, my lord.
Okay, so you wanted to say that for his art cutting, he has already lodged FIR.
Yes, my lord.
Okay. Thereafter only there was a complaint
Thereafter,
against you
yes, my lord.
before the GB, and GB decided.
Yes, my lord. And in that, my lord, eventuality, my lord, what happened? The Gaubura, my lord, has passed a decision whereby I was given a liberty to recall the cover decision. My lord, section 18 of our Arunachal Pradesh Civil Code Act, my lord, it says that the practice or the provisions of CPC, my lord, will not be applicable in the customary court, my lord. Now, my lord, what I say, now 15 days time has been given. Now, it is duty bound upon the village authority to recall the Kaba decision and initiate fresh Kabang, my lord. So, since this, my lord, against this decision, how can I prefer an appeal, my lord? There is no provision, my lord. After my representation, my lord, after my representation,
No, the Kaba
Yes.
order passed with a rider
yes,
that within 15 days you can
recall the Kabang, yes,
file.
yes,
So
my lord.
accordingly you filed.
Yes, my lord.
What is the decision?
Decision is at page 27, my lord. Their interpretation is that, my lord, I have not prayed for recalling of Kaba, but quashing of Kabang, my lord. Page 28 would be the translated copy, my lord.
Washing of Kaba.
Yes, my lord. It amounts to same thing, my lord.
That what if you file washing, then it's that's appeal.
No, my lord, I am filing same.
Challenging this order
Yes,
in the
madam.
same before the same court.
We cannot force that illiterate person of being known about language of the English, my lord. Now, my lord, he has filed a complaint, my lord. He has exercised his right for recalling of kebab, be it in another language, my lord, but he has exercised his right, my lord. Now, basing on that representation or complaint, my lord, the kebab should have initiated
So
fresh
this-
kebab, my lord.
This, according to you, is
Yes.
amount to a review.
Revision, yes, revision lies, my lord.
No. He has filed before the same court.
Yes,
Not
ma'am,
a
same
review.
court.
That's a review.
Same court, village authority, my lord. Yes, my lord.
That's a review.
As a review, my lord, for recalling of the kabang, yes, my lord. Because the liberty has been given, my lord. We cannot apply CPC in the customary court, my lord.
Okay, let us see what is the decision on your complaint.
Yes,
Yours again is a complaint again, not even for review.
My lord, the language, my lord, may condone, man, because these people, my lord, they cannot know the exact use of word, my lord. But we can at least assume that what he was trying to, my lord, get from the court, from the village authority. The liberty which was given, my lord, he was trying to exercise that right.
That means the language what he used,
Yes, my lord.
we have to speculate or.
My lord, the
So
intention of
when he says slave, then we'll assume it as a claim.
my lord, recalling kabang and recalling of kabang and for nullifying of kabang can be, my lord,
Receive. Just a minute. Let us, what is his decision then? Let us see.
and page 27, my lord. Translated copy would be page 28, my lord.
See.
I have received your letter note, and as I
Okay. He will not change the decision.
yes, my lord. Now, my lord, this thing, my lord, this observation, they are not appealable, my lord. The judgment is, my lord, conditional one, my lord.
Okay. So
Now, my lord, what happened, my lord?
okay, the GB meant to say that if the present petitioner, the respondent is aggrieved, he can call for reconduct of KEBA.
Yes, my lord.
But instead of reconduct or conduct of KEBA, he
Yes.
filed complaint. And then he said, now I will not agree.
Yes, my lord. Now, GB says, my lord, yes, I will not reconvene the kabang.
He will not reconvene
Yes.
because you were asked to
I have
call.
exercised my
and
right.
You did not call you. Instead, you have lodged complaint against me.
Not exactly, I have complained, my lord. I have not lost
I
complaint.
shall
my lord.
not change the KEBA. I do not have any bad feelings for me. And you do not have.
This is his
Not change the
own
KEBA.
personal, it is his own personal observation, my lord. So, my lord, firstly, we have to appreciate the.
So even if become my enemy also, I will not recall the KEBA meaning.
Yes, sir. Yes, sir.
Okay, so you are agreed by this.
Yes, my lord. But I am not praying for anything, my lord. I am only praying for trial, my lord.
Okay.
Since Kabang itself has given me some.
subsequently the execution process.
Yes, my lord. And thereafter, execution proceeding was initiated, my lord, by the respondent hearing, my lord.
Any order pass?
My lord, yes, that has been stated, my lord. That has been stated, my lord.
What has been
By this
stated?
honorable court, my lord.
No. What is the order passed by the executing court?
By executing court, my lord, in the meanwhile, my lord, civil court came into effect, my lord. Civil court came into effect, my lord.
Thereafter.
Yes, my lord. So again, as per Civil Court Act, my lord, it is the deputy commissioner who has the authority to execute KEBA decision, my lord. Now they have preferred execution before the district judge, my lord. So which was without jurisdiction, my lord. Against that, we have filed civil revision, my lord.
Okay. Execution petition was filed before?
District judge, my lord.
Okay, what order the district judge passed?
District judge has directed for my lord, that would be at page 49.
Relevant is 51.
Yes, my lord. Directed for execution of the command decision, my lord. The operating part would be page 51, my lord.
Okay, so DC shall engage one of his executive magistrate to demarcate.
Yes, my lord.
Okay, thereafter whether the DC has engaged or started demarcation.
Yes, my lord, page 53, my lord. This order has been stated, my lord. Both the orders has been stated, my lord, by this honorable court, my lord.
Just a minute. Mhm. Okay, where
My
is the
lord.
order?
Again, my lord, subsequent, my lord, what happened? They have filed an execution petition, my lord,
Executive
Yes, ma'am.
petition before the district judge.
before the district
Then
judge.
have
Now we
the
we
order
can,
passed.
my
Also, we
lord,
have seen.
my lord may, my lord, appreciate my facts, my lord, because that would be relevant for me, my lord.
No, just a minute.
Yes, my lord.
Just a minute.
Page 51, my lord.
Just a minute. They filed this execution petition before the district judge and district judge by an order dated. Just a minute.
Yes, ma'am.
Okay, this is 16-1.
Yes, ma'am. 16/123.
Past order.
Yes,
Then
ma'am.
thereafter.
Thereafter, my lord. My lord, to the facts, my lord. No, after.
No,
after
thereafter
this-
what happened? Let us
Oh,
come.
it has been
Next.
stated now. Thereafter, page 53, my lord. The SDO, my lord, Pasigat, my lord, has issued a notice, my lord.
What it says?
This is to inform that for demarcation of land, my lord, to be held on 17 to
Okay.
23, my lord.
For demarcation.
Yes, ma'am.
It's on 17. So then, what happened on 17?
17, nothing happened, my lord. We got a stay from this honorable court, my lord.
Okay, before this 17, you filed this
Yes,
stay.
yes, my lord.
Okay. Now what you want?
Now, my lord, the facts of the case, my lord.
Huh.
The page 29, my lord, they have filed execution petition, my lord.
That we have seen.
Yes, my lord. And against that, we have filed our objection, my lord, page 41, my lord. Now, my lord,
No, after that,
Petitioner.
after that only this district judge
My
passed
lord.
order.
yes, my lord. My lord, what happened? my
What
lord?
was your objection?
Yes, my lord. I was, my lord, not properly led by my learned counsel, my lord, in the district court, my lord. Why, my lord? May kindly see page 41, my lord. This is my objection, my lord. Page 41, my lord.
Yes.
This is my ground of delay, my lord. Page 41. My lord,
Delay, there was a delay also.
yes, my lord.
Delay in what?
Delay in preferring this civil revision, my lord. Instead civil revision, my lord.
Delay in preferring this civil revision.
Yes, my lord.
How it is connected? That was condoned, delay was condoned.
No, no, 227, there is no such limitation act, my lord.
Okay.
So
there
we
was-
have to only explain the delay, my lord.
Okay.
It's a subtle law, my lord.
So here, there is a delay in filing this civil revision.
Yes, my lord.
Okay.
Yes, my lord.
How
So,
many days of delay?
many days, my lord, we have explained.
Hmm?
We have explained, my lord. I have explained, my lord. May I
Explain in the civil revision.
Yes, my lord. In my para.
Okay. What else then?
My lord. See, my lord, page 44, my lord. What I am saying, my lord, I was not
Page 41,
properly.
this is in, before the district judge.
Yes, my lord. Why I am saying, my lord, I was not properly, my lord, guided by my counsel, my lord, in the lower court below, my lord, in the district court, my lord. My lord, may I kindly see the prayer portion, page 44, my lord, page 44. So my counsel was contesting the case for setting aside the cover decision before the execution court, my lord. Under the above facts and circumstances, the opponent most respectfully praise this honorable court to set aside and quash the cover decision dated so and so, dismiss the execution petition and may so and so. So I was not properly guided, my lord. Though we have been contesting the case, my lord.
This is in execution petition.
Yes, my lord.
Okay.
My lord. Now, my lord, this delay, my lord. Delay part I would like to submit, my lord. Page 14, my lord. Page 15, my lord, of my civil revision petition.
So,
Page
delay
15.
part, let us see, wait, huh?
Yes, my lord.
Yes, what is your contention?
Yes, your lordship. My lord, I have some judgments I want to submit, my lord.
What judgment?
Regarding revision, my lord.
Okay,
Civil revision, my lord.
we've
No,
seen the fact.
yes, my lord. My lord, firstly, my lord, I would like
Okay.
to I will go on this civil court act, my lord. Civil court act.
Okay.
Civil court act. 41. First, my lord. First, I would like to read my lord, section 18, my lord. Of the civil civil court.
21.
Yes, section 18, my lord.
Yes.
May I read, my lord? Application of the court, my lord.
Hmm.
The procedure prescribed in the court shall, save in so far as is otherwise provided by this act, be the procedure followed in all civil courts except the customary courts, my lord.
Hmm.
So, my lord, the provision of my lord CPC is not my lord, code has been defined in section 2C, my lord. My lord, may kindly section 2C, my lord, in the definition column, my lord.
Okay.
Code means the code of civil procedure, my lord.
Hmm.
So, application of my lord, this CPC
Hmm.
is not applicable to proceedings of customary court, my lord.
Hmm.
Now, my lord, section 15(3), my lord. Section 15(3), proviso 2, my lord. Second proviso, my lord.
Good.
Yes, my lord.
Yes.
May I read, my lord?
Hmm.
Provided further that from the date of commencement of this act, in case an appeal is prepared against the judgment of
Section 15.
proviso, second proviso, my lord.
Okay, proviso.
Yes, proviso.
Second.
Provided further
Okay.
second.
Yes. Hmm.
Provided further that from the date of commencement of this act, in case an appeal is preferred against the judgment of customary court in the court of district judge or in the court of additional district judge, as the case may be, the court of district judge or the court of additional district judge may dispose of the same, proceed with the case de novo, my lord. Now, my lord, this was earlier, my lord, provision, my lord. Subsequently, there was some amendment, my lord. Amendment of 2022. Though it is same thing, my lord.
Amendment to.
2022, my lord.
Yes.
My lord, may I kindly see the third proviso, my lord. On the top.
3 of subsection 3 of 15.
Yes, my lord.
Third.
Yes, my lord. Provided also
1,
debt,
2. Provided.
also debt, in case an appeal is transferred
Just
by the
a minute,
deputy.
Wait. Provided.
Provided also debt,
In
in case an appeal is
provided one. Okay, yes.
on the top, yes, my lord.
Hmm.
Provided also that in case an appeal is transferred by the deputy commissioner or preferred against the judgment of the customary court, my lord. Now, my lord, this judgment, my lord. Judgment has to be, my lord, a concrete judgment, my lord. It has to attain its finality, my lord. Appeal is maintainable against the judgment, my lord. what I am saying, my lord, this cover decision, my lord, is not a final judgment, my lord. It has given me 15 days time to recall the cover decision, my lord. And I have exercised that right, my lord. Appeal, my lord, is maintainable against the cover, this judgment of the customary court, my lord.
No, you were given 15 days,
Yes, my lord. I have exercised that right.
exercise that, and thereafter, finally it was decided.
They declined, my lord. They
Hmm.
declined, my lord.
Decline is the decision.
My lord. But, my lord, whether, when they had itself given me right in the judgment, my lord, in the
No,
decision, my lord.
that right you have already exercised. After exercising that right, it was finally decided.
So, my lord, whether they can, my lord.
Disposing of your complaint.
So why, my lord, whether they can, my lord. When they itself, themselves has given me certain right, my lord. Whether they can deny me of that right, my lord.
Yes. You are challenging that order only.
Yes, my lord.
Okay,
The Keval decision and that order also.
but that is a final order otherwise.
That
Because it
cannot,
disposes of your application.
yes, my lord. Yes. That is the final order, my lord.
That is final.
Against that, I have before this honorable court by way of revision petition, my lord.
Okay.
Because, my lord, revision, my lord.
Revision.
Yes, my lord. Under 227, my lord. So, my lord, why, my lord? They are not
If it is
exercising their
if it is a
jurisdiction.
final, if that is a final order,
Yes.
final appeal,
Yes, my lord. It can be, my lord. I will,
in the revision,
yes, my lord.
what is wrong in it?
My lord,
The,
they,
in
my
the,
lord,
in the, in the,
they are with
wrong
the
in the
jurisdiction, but they are not exercising their jurisdiction, my lord.
what jurisdiction they have
Because, my lord,
exercised?
they have themselves has written in the order, they have themselves written in the order that I can recall the cover within 15 days, and within 10 days I have tried to recall. But they, my lord, refuse to recall the cover decision. Now, my lord, that is not a, my lord, judgment on merit, my lord. That is simply not exercising their jurisdiction, though vested to them, my lord. I would like to 1997, 5 SSC.
So by this order dated 16/3/2020, we, the GB had affirmed his decision on 19/2/2020.
Yes.
Since you failed to call KEBA, you were asked to KEBA, given an opportunity just to call KEBA, and you did not call, and that is why he has, by this order, he has affirmed the order passed on 19/2/2020.
So,
So this is the final order.
yes, my lord, we cannot,
So-
yes, my lord, what I am saying, my lord, we cannot expect a rustic villager to be aware of various, my lord, words of English, my lord. So it was only written in local language.
It's not a question of English,
Yes, my lord.
because they have passed in a vernacular language.
My lord, records has been called, my lord. I think records may be there, my lord. Records, my lord. Records, my lord. Records was called for, my lord, in this case also. My lord, may see the judgment. Para 10, my lord. After, yes, para 10, my lord.
Yes.
Para 10, my lord. Yes, ma'am.
Yes.
Yes, ma'am. May I read? Power of superintendence to the High Court under 227 of the Constitution is not confined to administrative superintendence only, but such power includes within its sweep the power of judicial review. The power and duty of the High Court under Article 227 is essentially to ensure that the courts and tribunals inferior to High Court have done that they were required to do. Law is well settled by various decisions of this court that High Court can interfere under 227 of the Constitution in cases of erroneous assumption or acting beyond its jurisdiction, refusal to exercise jurisdiction, error of law apparent on record as distinguished from a mere mistake of law, arbitrary or capricious exercise of authority or discretion, a patent error in procedure, arriving at a finding which purpose or based on no material or resulting in manifest injustice. As regard finding of the fact of the inferior court.
See, the Gambura GB has a jurisdiction to decide your case.
Yes, my lord.
He has
So he-
decided by 19
Yes, my lord.
two, but of course,
The second order, my lord.
with the rider.
Yes, my lord. The second order,
Only
he
one.
refused.
And thereafter you file, and then while exercising that, entertaining your petition, he has affirmed his decision. So
Yes,
this
ma'am.
is final.
So, my lord, what I am
What-
saying,
What is a jurisdiction error?
my lord,
Yeah.
here, my lord, refusal to exercise jurisdiction, my lord. Now,
It's not,
Kabang
it's not a
decision.
refusal. He affirmed his own decision.
Yes, my lord.
Once he has given an opportunity to.
Yes,
you
ma'am. Yes, my lord.
for
And I have
recalling-
exercised that right. ma'am.
So by exercising that only he has affirmed decision.
So,
By
whether
this order, final order.
if he says, my lord, the village authority says this is the judgment, final judgment, my lord. Now, if that is the final judgment, it also creates right in favor of me also to recall the Kabah decision within 15 days, my lord. Now, within 10 days, I have recalled the Kabah decision, my lord. Now, that order, if it has attained finality, my lord, it is also in my favor, my lord. So I have the right to recall the Kabah, my lord. So I have exercised my right. Now they are duty bound by their own judgment, my lord. So since they are not exercising their jurisdiction, my lord, they are refusing to exercise their jurisdiction, my lord.
They
227,
are
my lord.
not exercising his jurisdiction, doesn't err, it appears. Anyway, just wait. Huh?
My lord.
Yes,
Yes. Yes,
what do you say?
yes, yeah, but my contention would be that already the Kabah decision which has arrived its finality should not be set aside here. Their opportunities were given 4 times. Kabah was called and he deliberately refused to attend the Kabah, for which the Kabah passed a final decision on 19/2/2020, conferring right and ownership to the respondent. So, village authorities also, Your Honor, while passing the Kabah in point number 4, gave him again another opportunity. Already that has been discussed, Your Honor, that to recall a Kabah within 15 days. But he does not agree with the Kabah that so and so. But he failed to approach the Kabah as directed, Your Honor. Rather, by a letter on 28/2/2020, the petitioner informed HZB Boeing about the registration of a police case so against the respondent, but no prayer for recalling or reconducting a Kabah. There was no any prayer. As per the language of the letter, Your Honor, 16/3/2020, HZB Boeing Village clarified that despite you were given time of 15 days to recall a Kabah, but you failed. As such, no more Kabah would be conducted, and the Kabah dated 9/2/2020 cannot be set aside and quashed, Your Honor. In such situation, the decision has attained its finality, Your Honor. There is no reason to reconduct a Kabah. And when it has attained its finality, Your Honor, its remedy lies for appeal only, nothing else. So, rightly or wrongly, Your Honor, Your Lordship, the decision has been passed. And by exercising this 227 revision, Your Honor, this will increase the right of the respondent when he has an alternate remedy.
Yes, anything else? But see,
Yes.
This was decided on 20.
And then 2020, before the enactment of Civil Code Act.
Yes.
So whether before enactment of Civil Code Act, he has a right to decide ex parte.
Yes, Civil Code Act,
Mm.
you know, the two, it
Or
was, yes.
The Civil Code, of course, that is clear. After giving an opportunity 3 times
Yes.
after gap of 1 month.
Here 4 times was given here. 4 times he was.
No, what I'm saying is even 4 time, whatever maybe, but then whether the Gambara, a lone Gambara has a power and jurisdiction to proceed, decide ex parte in absence of the party respondent prior to the enactment of Civil Code Act.
Yes, you know, in that case also, the AFR didn't bar the this procedure of CPC. Then later at this point, it should have been, it has been followed.
Where do we find that can decide after giving an opportunity to the?
There is no specific provision like that. But
Okay.
impliedly, this that CPC procedure is still, it won't bar.
And this, while affirming the order also, it was also 2020 before enactment. But when he filed this execution petition, the Civil Court Act has already been enacted. Then by the enactment, it is Deputy Commissioner who has a power for execution, and it was filed before the district judge. What do you say?
Yes, you know, that is correct, the order. Yeah, I concede with that because during that, it was transferred from DC only to the district judge. It was filed before the DC only, initially.
Is it?
Yes.
No, this is addressed to the district judge East Chiang Pasigat.
Yes, Your Honor.
This was in 2022. See,
Yes, yes.
page 29.
Prior to that, Your Honor, we find that the proceeding started from.
No, it doesn't say so. It doesn't
Deputy
say so.
Commissioner. In my reply on Annex 1.
And it doesn't say so because the application is district judge in the year 2022 for execution.
Your Honor, may kindly come to my affidavit in opposition. That Annex 1, page 10.
Yes.
Yes, this was, first of all, this execution case was brought before the Deputy Commissioner.
Yes. Just a minute. This is regarding, probably this is regarding trial. Says that now after enactment,
Yes.
the Deputy Commissioner had no more jurisdiction to try, not for execution.
Your Honor, it was actually execution only. Execution 01 of 2021. This is written in the top. It was execution. But
Okay.
they misunderstood the provisions of law and they sent it to the district judge. And again, during the pendency before the district judge, again law was enacted. And at that time, the district judge, without having the knowledge of that, about that enactment, had tried to execute and passed a notice. That is the area. So this execution matter can be, you know, remanded back to a proper forum.
Okay. Anything else?
That's, I'll rely upon this judgment of this honorable court only in two cases. In Kirmar Kamcham versus Nidoram Rumdo. For a 7 year.
Paragraph 7.
Yes.
Yes.
In the instant case, the petitioner did not file any appeal against the decision of the Kaba dated so and so. There is enforcing the decision of the Kaba. Unless there is an appeal, the execution proceeding cannot be stayed or set aside. Therefore, the petitioner is presented a bad case seeking relief. The petitioner has to file an appeal against the decision of Kaba dated so and so. The Kaba cannot be quashed by the High Court in a manner as desired by the petitioner. Then in another case of ego bomb, alias ego bomb, Para 31.
Yes.
Yes, it says that over here also, when there is an alternate remedy owner, as per the office.
Yes.
Yes, not so and so. As authorities have made or know this so and so, while the petitioner here always can come up with the review appeal so and so. In the petitioner has alternative remedy, as such, this court is not inclined to use the discretionary powers under Article 226 of the Constitution of so and so in the review so and so. Therefore, when there is a remedy, this is not maintainable. CRP is not maintainable and it may be dismissed.
This was 226.
Yes.
Under 226 only.
Under the writ
But
petition.
the present petition is under 227.
27. The other one is on the under 227. The Kirman Kamchamu. Yes, that one is under 227.
So, since the petitioner or the petitioner could have filed appeal.
Yes.
Since it's not an appeal, this cannot be. Yes, my lord.
My lord, what my condition is that, of
This is
course,
final
my lord,
order.
my lord, of course, my lord, if there is a complete final judgment, my lord, appeal is maintainable. Now, when there is a condition in the judgment, my lord, how can it be appreciated, my lord?
No, your condition given to you, you have already exercised the condition given to you,
My
and
lord.
that has been disposal. That disposal is final, what I'm saying.
My lord, I say, my lord,
That
they should have exercised their jurisdiction, my lord. They cannot have refused, my lord.
No. Refusal, that is your discretion. See, refusal, acceptance, that is discretion, but the disposal itself is a final.
But so why, my lord, whether that order, my lord, whether it is, my lord, rightly passed or wrongly passed, my lord, that has to be appreciated. My lord, because the final judgment has to be appreciated. The final
The order, the status of the order, whether it is final or not, is a question here.
Yes, my lord.
Not right or wrong.
My lord.
Because rightly, wrongly, that is his exercise of his discretion. We
My lord.
cannot.
My lord.
But then whether it was, this is the final order against which
My lord, in the-
appeal only, appeal
Yes,
will
my
lie.
lord. In that case, my lord, 2006 3 SSC, my lord. 2003 6 3 SSC, my lord. I have some judgment, my lord. 2006, I have some judgment. 2006 3 SSC, page 312, my lord.
That is regarding what?
Wrong appreciation of improper appreciation of my lord, that question of law, my lord. Para 13, my lord. 1-3, my lord. Jurisdiction under Article 227 of the Constitution, my lord. Para 13, 2000, my lord, 6 3 SSC.
Yes.
Yes, my lord. Page 312, my lord.
312.
312, page 312.
But
Now,
relevant is
relevant is page 13, yes, my lord.
Yes.
Yes, may I read? The jurisdiction under Article 227 of Constitution may be restrictive in the sense that it is to be invoked only to correct errors of jurisdiction. But when a court asks itself a wrong question or approaches the question in an improper manner, my lord, even it comes to a finding of fact, the said finding of the fact cannot be said to be one rendered with jurisdiction, and it will still be amenable to correction at the hands of High Court under Article 227 of the Constitution, my lord. The failure to render the necessary findings to support its order would also be a jurisdictional error liable to be correction. Now, my lord,
What? You want to say?
my lord, yeah, when court asks itself wrong question, my lord, it has given me and my lord liberty, my lord, a right, my lord, to recall the kaba, my lord. Now, it was a duty of the concerned village authority, my lord, to convene the kaba, my lord. Now, refusal to convene the kaba, my lord, it has been answered in a wrong.
Maybe refusal or allow or whatever may be, but the decision of the Gambara is final, what I am saying.
Yes, my lord. But my lord,
He has exercised
no,
rightly or wrongly, but then he has exercised his jurisdiction
my lord,
correctly, because
Alright.
as a Gambara, he could not have passed order more than that.
Right.
Okay, but then he has passed. The decision may be right or wrong.
Right.
That is different, but then his decision is a final.
my lord. Then, my lord, I have two more judgments, my lord. So that, my lord, this is regarding conditional order, my lord, passed by the, my lord, civil judgment.
No,
May.
yes, conditional order, that is we have crossed, because conditional order, thereafter you have exercised,
Yes,
that
ma'am.
condition given to you
My lord.
to file application
Ma'am.
for recall of Keba,
My lord.
that you have already exercised. Thereafter only he has exercised his power and disposed of the matter, rightly or wrongly, that we do not, but then he has disposed of.
My lord.
And that disposing of your subsequent application,
My lord.
the liberty given to you,
Yes,
that
ma'am.
disposal is a final order.
My lord. That, my lord, what I say, my lord, a judgment basing on the facts, my lord, is appealable, my lord. Now, this, my lord, whether that a letter issued to me that yes, we will not convene a final decision, whether it is appealable, my lord, against the decision, against the judgment.
Any final order is appealable. Let us see the
Well,
CPC then.
We cannot see the CPC because, my lord, the
Maybe, but
customary
then,
court, my
but
lord,
then for that, for understanding what order or order is appealable.
but
Any order disposing.
any decision of final order, my lord.
Yeah, decision. This is decision final order only.
It is, my lord,
It's not interlocutory.
it is not, I say,
The
my lord, it
disposing
is,
of your petition.
my lord.
It's not an interlocutory order. Finally disposed. He said denied completely. I will not.
My lord. My lord, in that case, my lord, one last judgment, my lord, sorry, 1964, my lord. 1964 SC 497, my lord. Against the final order also, my lord, appeal, my lord, revision is maintainable.
Against?
Final order also, my lord, revision is maintainable, my lord.
Okay.
Yes,
Where is that?
Yes, my lord. Yes, page 497, my lord. Para 15, my lord.
AK Sarkar.
Yes, my lord. Para 15, my lord. May I read, my lord?
Para 15,
Yes, sir.
page.
Page, my lord, I have the online copy, my lord. My lord has the hard copy. The next question, my lord. Yes, para 15.
15. Okay.
It starts with the next question, my lord.
Hmm.
The next question which was to be determined is whether the High Court has power to set aside an order which does not finally dispose of the suit, and when from the decree or from final order passed in the proceeding an appeal is competent, relying upon the use of expression in which no appeal lies thereto in section 115 Code of Civil Procedure, it was urged that the High Court's jurisdiction to entertain a petition in revision could be exercised only if no appeal lay from the final order passed in the proceeding. But once it is granted that the expression case includes a part of a case, there is no escape from the conclusion that revisional jurisdiction of the High Court may be exercised irrespective of the question whether an appeal lies from the ultimate decree or order passed in the suit.
What is this?
It says, my lord, even there is a final decision, my lord, revision is maintainable, my lord.
Only if no appeal lies.
Yes, sir.
It says that only if no appeal lies. But here is a case, there is a final,
Yes, my lord.
final order.
May I
appeal
again,
lies,
my lord?
Appeal
The
lies
next question.
against the final order.
No, it says, my lord, even if there is a final order, my lord, revision is maintainable. The next question which was to be determined is whether the High Court has power to set aside an order which does not finally dispose of the suit, and when from the decree or from the final order passed in the proceedings an appeal is competent, my lord. Relying upon the use of the expression in which no appeal lies thereto in section 115 Code of Civil Procedure, it was urged that the High Court's jurisdiction to entertain a petition in revision could be exercised only if no appeal lay from the final order passed in the proceeding. This was the submission, madam. But once it is granted that expression case includes a part of a case, there is no escape from the conclusion that revisional jurisdiction of the High Court may be exercised, madam, irrespective of the question whether an appeal lies from the ultimate decree or order passed in the suit, madam. Otherwise, my lord, may kindly take up this matter on next Monday, my lord, so that I will produce some more judgment, my lord, to satisfy this honorable court, my lord.
So, according to this, is not final order.
Well, this is against the final order also, my lord. Revision is maintainable. This was the interpretation for section 115, my lord. And article 227 is very vast, my lord. The catching point here is, my lord, but once it is granted that the expression case includes a part of a case, there is no escape. Para 15, my lord. But once it is granted that expression case, my lord, includes a part of a case, there is no escape from the conclusion that revisional jurisdiction of the High Court may be exercised irrespective of the question whether an appeal is there, lies from the ultimate decree or order passed by the court by passed in the suit, my lord. So decree, my lord, it is a finality, my lord. So even against that, my lord, revision is maintainable. Otherwise, my lord, I may be produced. I would like to submit more some judgment, my lord. This matter may be listed next week, my lord, so that I can produce more judgment, my lord, whether the revision, because my case, my lord, I only want a trial, my lord.
But why you did not file appeal?
Appeal, my lord. See, my lord, what I have submitted, my lord, I have been led by the council in a wrong way, my
You
lord.
have been given an opportunity.
Yes, but I have been led by
Why
council
appeal?
in a wrong manner, my lord. And secondly, my lord, what happened, my lord? My lord, may kindly see this, my lord. Our Supreme Court order, my lord, where, my lord, due to Corona, COVID-19, my lord, the limitation was extended, my lord. And because of that, also, my lord, I could not prefer an appeal. For 2 years, my lord, I could not, my lord, pursue my matter, my lord. And in that view of the matter, also I forgot, my lord. Meanwhile, they have filed an execution petition, and I have been, my lord, defending myself in a wrong forum, my lord. So suddenly, after, my lord, we have approached this on record, my lord. Or next week, my lord, after a week, my lord, so that I can produce some more judgment, my lord.
No, what we'll
The
do?
moot question your honor, your lordship is asking is whether revision is maintainable against the decision, my lord. So I will answer on that issue, my lord, with more judgment, my lord. So can it be after a week? Otherwise,
After a week, the judge will change. But then I have heard next week or Friday or Thursday,
It can
this
be
Thursday.
disposed of. We have already heard. There is nothing to.
I will submit more judgment, my lord, on the issue whether the appeal, whether the revision is maintainable or not, because the core issue is that, my lord, now.
Yes.
Yes. So I may be given some more time, my lord, 1 week, my lord.
Huh?
Next Monday, my lord.
Next Monday, then again, over and again, it will have to be had.
We
Then.
will be again more clarify on the facts, my lord.
There is nothing.
But this
to
court will
clarify.
not be again there.
My lord will be there.
The issue is,
No, next week I'm not there.
Well, oh my lord.
we can submit the judgments anytime before the order.
Next week, my lord.
Next
I
week.
will submit more judgment only on that issue, my lord.
This is your lingering for many occasions. Then we are coming all the way from Procedural. We could have disposed of this matter today.
Then we'll fix on Thursday.
Next Thursday, my lord. This Thursday, next Thursday.
This Thursday.
Yes.
Yes, my lord.
Okay. This Thursday.
Yes.
On the prayer of Mr. B. Picha, not a counsel for the petitioner, release this matter again on Thursday for further hearing. Okay?
Yes, my lord. Right. Obliged.
Lord, today matter has come for admission. So my lord, she may admit the matter and want to fix it for hearing. Because otherwise, my lord, is almost, my lord, is the settled question, already question was settled. A long continuous cohabitation with a promise, whether that will constitute RAP or not. Number of decisions are there. Our High Court also observed that since there is a consent and she is a major, and despite her, my lord, consent, once a cohabitation took place, that perhaps may not constitute offense. So Lordship will my lord, examine this question and admit the matter and fix it for you.
Yes.
I don't want to trouble your issue today. And
Probably.
there is an interim order.
It was not yet admitted.
Not yet admitted. So without admission, perhaps not hearing may not be justified. High Court has already, my lord, decided this question. Yeah, once there is
Entire matter can be disposed of
one, my lord.
in the admission stage.
My lord, today I thought, my lord, it may require some time, my lord, and I thought, my lord, proceed and admit the matter and fix the date for hearing. Because there are a number of decisions I want to cite, and my lord, we have come hurriedly, and some decision we could not bring, my lord.
376.
One, my lord, 376.
Hmm.
376 and 493. Therefore, the question
There is
arises, my lord,
allegation. There is
Madam-
allegation against you.
and my lord,
There is allegation against you.
allegation against me.
Uh,
But whether it is, my lord, my lord, conscientious relation. And interim order, while court has granted interim bail, court said that yes, she has given her consent, there is a total voluntary surrender on her part, and she continued for about, my lord, more than 6 months. And all of a sudden,
but there is an allegation that initially it was
Initially, madam,
forceful. It was
initially-
forceful.
initially, my lord, 6/2/2022,
Hmm.
this is the only allegation that there was forceful. But I am in a position to justify
Thereafter subsequently continued with the
Yes.
on promise.
on promise. Therefore, my lord, whether the promise may be an essential.
That need you see that the trial court is the best court to prove that whether it was there was
Even that-
consent or not.
Even then, Supreme Court says, my lord, now the number of decisions are there. Supreme Court says, my lord, if the continuation of trial, my lord, without any basis, that will amount to a video process. Therefore, my lord, it requires some time, my lord, I would say so. First, rightly pointed out that on the very first day, there was an attempt for, my lord, petition. But I am in a position to justify that this is absolutely a false allegation. It doesn't depend, my lord.
Whether it was false or not,
No, lordship.
that is- trial only it will be yes, it will be
Supreme Court says,
determined.
may not, Bhajanlal's case may not, if falsity is apparent on the face of the record, then it may be one of the tests. That may be one of the guidelines, my lord, for the court to examine. Therefore, I am not saying that, my lord, it is. has
So
to
how
be-
this court will decide the fact? Disputed fact.
my lord, from the charge sheet, my lord, itself,
Hmm.
they can show.
See, entire charge sheet, everything is available.
Everything is there. Here I have
Available.
an.
So then why don't you see, why not this case be decided by the trial court?
My lord,
Because it's dispute or a fact
my lord,
only.
if my
Fact is
case,
to be proved before the trial court.
that's right. If my case falls within the parameter, I say that there are certain parameter, and if my case falls within that parameter,
Charge also not framed.
pardon, my lord.
Charge also not framed. Framed.
Not-
Already framed.
Not framed, not.
Not framed. See, why don't you take chance
My lord, from the.
before the trial court
That's right, my lord. I am
for
not
this
disputing.
for discharge?
My lord,
Entire this argument with this entire argument.
even then, my lord, is my appeal before your lordship, my lord. Give me one more chance so that I can satisfy your lordship. Today, it may not be possible because we have come very hurriedly. All records are also, we could not bring.
Lordship, as my lordship has rightly pointed out, at this stage, quashing stage, lordship, my lordship has to see whether
Yes.
the uncontroverted statement made in the FIR, if it constitutes any offence or not. Lordship. Here is an allegation, lordship, prima facie.
And
You
my
have
lord,
seated.
But then he is seeking for one more chance.
yes,
Okay, let him prove.
next day,
Today he's not
Next,
very.
they are enjoying the interim order, lordship. So may I humbly pray that my lordship may admit it today and fix it for a hearing next week.
Okay.
next week, it
Mr.
may
Eki,
immediately
Mr.
after
Eki.
vacation.
Take a podcast, and counsel for the petitioner. Also had Mr.
After vacation
Mr.
also, they want to enjoy the interim.
Mr. Loy, huh? Then PP for the state respondent number 1. And Mr. Lolen, huh? K. Lolen, then counsel appearing on behalf of the respondent, private respondent number 2.
Yes, lordship, I am for response.
2 star, huh? Whether the trial court record receipt. Okay.
Yes, yeah.
Yeah. Since the parties are duly represented and the trial court record has also been received, the matter is admitted for hearing. So at least this matter is requested by the Nana Council for the petition. At least this matter again. When do you want to say?
Well, after vacation, my lord.
Well, after vacation.
Yes.
Fixed date may be given, lordship.
Lordship, today is 16. Let it be on 3 July, 3 July, any date, my senior is
After
convenient.
vacation. Let him find out the date.
1, 2, 3, 4, sir.
Roshi is going to fix on which date, my lord? Our High Court will remain reopen on, my lord, 17.
Yes.
17.
Can it be on 1, 2, 3, 4 July?
July may not be possible, my lord. After 21st.
22.
Can you admit the matter?
No further.
For hearing, huh?
Yes.
Okay. Yes.
May I please submit mine?
Yes.
My lord, this criminal petition is for quashing of FIR and the subsequent charge sheet. During the pendency of this matter, my additional affidavit is
Start with simultaneously.
my lord,
Page.
158,
One.
additional affidavit.
Yes. No. Kindly read the.
Withdraw the individual cases filed by them. The third party shall file an affidavit before the Honorable Itanagar Bench of Guwahati High Court in criminal petition so and so, the instant matter, apprising the Honorable Court of this MOU and confirming that he has no objection if FIR number here, my lord, in their page 147. Additional affidavit filed on their paragraph number 3,
Okay.
where they have also
Hmm.
admitted the fact that, may I read, my lord, paragraph
Yes.
3, that as per the MOS, after the
Para 3.
para 3, page 147.
This is.
Respondent number 2 and 3. It starts with page number 145.
145. Yes, para 1, para 2, para 3 start from that during the pendency.
My lord, may I see the records, my lord, because it should. My lord, settlement agreement, they have also annexed in that same.
Incorporated here itself,
Yes, they have annexed in that page. It starts from page number
149.
149, my lord.
Okay.
My lord, the basic points were laid down in page number 145, 151, sorry, 151. My lord, of this additional affidavit
Yes.
of the respondent number 2 and 3.
Hmm.
Here, my lord, the basic points are number 1, whereas all the above individuals are herein after collectively referred to as the parties and individual as a party. Number 2, whereas all parties are related to each other through the marital bond of the first party and the fourth party.
Okay.
Number 3, whereas the first party and fourth party came in contact in the year 2020, decided to marry, and were socially married on 21/11/2021 at Guwahati according to Hindu rites and customs. Post-marriage, they cohabited at their matrimonial home in Gurugram. Number 4, whereas the dispute between the parties arose as because the first party and the fourth party were not pulling on well in respect of their marital relationship, and they have now been living separately for more than 2 years since 14/9/2022.
Okay.
5, where there has been the first party and the fourth party after 9 months of conjugal life, and the fourth party left the matrimonial house on 14 September 2022 and began residing in Raipur with her family. Number 6, whereas the parties has instituted the following cases each other or their family members and relatives. My lord, this list of cases,
Okay.
all has been wide this agreement
Okay, so this.
were settled in
This petition is for quashing of which case?
at serial number
Balupong,
serial number 8
serial 8.
of this table, which is at page number 154.
We are concerned with serial number 8
Yes.
of the table.
F number 5 of 2023 and charge sheet number 4 of 2025, which is from Balupong police station.
05.
Yes.
Yes, okay.
My lord, to conclude my submission, my lord, this we have invoked the inherent power of this High Court under Section 482 to quash it, as the parties have already settled. So in the interest and in order to securing the ends of justice, the matter may be disposed of today, my.
Yes.
Yes, may it please your lordship.
Yes.
Your lordship, I would raise objection on maintainability at this stage. Why? Because your lordship, initially they have invoked 482 for quashing of FIR on merit for offences which were compoundable. If it is on merit, no doubt it is maintainable. But now they are approaching this court, filing an agreement, additional affidavit to bring into the record their settlement by both the parties. That is also admitted. But the question here is whether the extraordinary inherent power of this court can be invoked for the offense which are compoundable, which can be compounded before the learned trial court itself, your lords.
This is compoundable offense.
Yes, all the offenses are compoundable.
All the offense.
Yes, your lordship. Initially, they have preferred this criminal petition on merit, your lordship. For merit, there is no any, your lordship, hindrance for them, your lordship. But now they are on settlement. And if it is settlement, the compound can be done by the trial court only, your lordship. Under section 320 of the CRPC, which where
since the party was not in agreement, so it came.
Yes, your lordship.
Okay, now the parties have agreed.
Yes, your lordship.
To compound.
All the offenses are compoundable.
What the law says, law says.
Your lordship,
regarding the compoundable case.
Yes, your lordship. The offences which are not compoundable under section 320 can be compound an exercise of the extraordinary power under section 482 or the inherent power corresponding section 528, where the offences are overwhelming of civil nature, parties has entirely settled the dispute among themselves, or commercial transactions are there, where the parties has settled the dispute entirely among themselves, and the offense doesn't fall under the category of the offenses which has been provided in section 320 of the CRPC or 359 of the corresponding section of BNSS. Now they have a remedy before the trial court. There is no any required to exercise the inherent power of this honorable court.
What the law says now regarding the compoundable case.
Yes, your lordship. It is in Lakshmi Narayan also, your lordship. In all the settlement cases, this part in Lakshmi Narayan also in the first line itself, it has clearly says the offences which are not compoundable under section 320.
But then now after agreement.
Yes, your lordship.
After their Supreme Court, you have gone for mediation.
Yes, it's a mediation, your lordship.
After that, it has come to. It has, see, now both the parties agreed.
Yes,
now,
yes.
What the law says.
Your lordship, that is what I am trying to submit. Now they have a remedy before they can approach the trial court, your lordship. Power, inherent power, your lordship. They have a remedy under 320. The learned trial court will compound the matter, your lordship.
What do you say?
May I please submit my lord? The trial has not started yet. Only the charge sheet has been filed. My lord, why to abuse the process of law when it can be done under 482 by inherent power of this honorable High Court?
Record everything and direct the trial court to pass order.
Yes, your lordship, absolutely.
Okay. My lord, 482 inherent power, my lord, it can be caused here itself, my lord. There's nothing in case, my lord, when they settle between the parties.
Say that in terms of the order, the trial court will compound.
And my lord,
exercise power under 320.
my
or
lord, in my humble understanding of law, my lord, even under 482 it can be quashed, my lord. Inherent power of the discretionary power of the Honorable High Court, my lord. It won't be any wrong, even if it is quashed at this stage, without reverting it back to the lower court, my lord. That is my humble understanding of law, my lord.
Okay, I'll pass order, necessary order.
Yes, your lordship. Because your lordship, for invoking
Let me
inherent
just
power,
clarify one law, huh?
there must be,
Then I'll pass order.
yes, exceptional circumstances.
This is exceptional circumstances. Earlier it was contested on merit. Now,
Yes.
since they have agreed, and then probably this court can pass a certain order, and then they will only have to appear once to.
My lord, the trial has not begun yet.
Will not direct for trial or anything, but then pass order, and but then once you have to appear.
Yes,
before
your
the trial
lordship. In according with the
In
provision
accordance
of the
with the
law.
law.
Your lordship.
Okay.
Obliged, my
Okay,
lord.
hard, Mr. Jamu. HK Jamu, Land Counsel for the petitioner. Also hard. Yeah, who is for private? You are for.
I am for the private.
Okay, private respondent is the respondent number 3.
I am for the 3.
Okay.
I'm for respondent.
May it please
your lordship. I appear for the respondent number 2, your lordship.
Okay, just a minute, man.
Tomorrow 2 and 3.
For respondent number 2 and 3, Mr. Sharma and Mr. Omo.
Yes, your lordship.
Who is, one is state. State is one.
Respondent number 1.
Mr. T. Land additional PP. Also have Mr. T. Land additional PP for the state respondent number 1. Mr. S.P. Sharma and Mr. T. Omo appearing on behalf of the respondent number 2 and 3, and Miss
Body for respondent 4.
Give name, huh?
4. Embody.
Embody for respondent number 4. You have no objection? Okay. Okay, I'll pass necessary order.
Obliged, my lord.
Obliged, your lordship.
Obliged, your lordship.
Dispose, chamber. Yes.
So the matter relates to, my lord, an acquisition. Appeal has been filed by the NIPCO against the appeal has been filed by the NIPCO
Okay.
against the judgment and order of the London district judge.
This was already admitted.
Already admitted, my lord. Already admitted. It should have been
in the hearing column.
Should have been listed. Because the matter was admitted earlier, my lord.
Yes.
So, my lord,
So whether record received?
record received, my lord.
Record also
Record
received.
received, my lord. We have also taken certified copy or the lordship granted.
Okay, you have received the entire certified copy. Then can we fix for hearing?
This one, I beg to please one thing. We have in the meantime also approached that if there can be a settlement of the matter.
Yes.
So if a hearing date is fixed, in between, if we can work out anything.
We have no instruction about that, my lord. So if they have filed, deputy commissioner has taken any steps, my lord, let it proceed, my lord. There is no bar. Lord, your lordship has not given any order that cannot proceed and all that. So let them proceed.
Okay.
But my lord, as far as we are concerned, my lord, we do not know anything about it.
Okay.
So let the matter be fixed, my lord, if not inconvenient to my lord and my friend, my lord, 23rd of July.
Okay. Mr.
Well, K. Agarwal.
K. Agarwal, Land Counsel for the.
D. Senapati.
Okay. D. Senapati, Land Counsel for the appellant. I've also heard Mr.
Pathak B. Pathak.
Pathak, Land Counsel for the respondent. How many respondents are there?
There are not 71 respondents.
You are for representing how many respondents?
I am representing the landowner. It's up to
71.
71.
Up to 71. 1 to 71.
72. 72 is the deputy.
70 is the collector.
1 to 71. And Miss Bangma. For and counsel for appearing for 72 is the state.
74.
Okay, state respondent. Since the party are duly represented and the record has also been received, let this matter be listed for hearing
On 23rd of
Okay.
July.
Okay.
July.
on 28th July.
23rd, 23rd of July.
23rd, huh?
July.
July for hearing. Start.
My lord, I have one prayer. My lord will kindly see on the last occasion, they've given an undertaking that, my lord, since we are pressing the stay, my lord, they said that we will not execute since the matter is hearing. So, my lord, let it continue till the conclusion of the hearing.
Stay.
The execution is.
So, your lordship will kindly, the last order, your lordship will kindly see 7/5/2025, third paragraph. On the other hand, Mr. Pathak, learned counsel for the opposite party in his usual fairness submits. My lord got it, my lord. Appeal is pending. They will not pursue the execution proceeding as of now. However, matters should be heard at the earliest, and appealants should not delay the matter in taking unnecessary adjournment. In view of the consensus that the matter so and so, taking note of the submission of Pathak, learned counsel, they will not pursue the execution. This court restrained to pass any interim order.
So what do you want now today?
Lord, let the undertaking given by him continue, my lord, till the conclusion.
My lord, execution is on 24th, anyways we have fixed it here 23rd. Definitely execution will not be able to happen.
But after doing the matter here on 23rd, my lord, it will not be possible. So Lord, let the undertaking continue, my lord.
In the meantime, the undertaking
Given by Mr. Pathak, my lord.
given by Mr. Pathak, Learned Counsel for the opposite party on 7/5/25 that continue. Okay.
That will.
No, let them also have instructions on the aspect of mediation, my lord.
Okay, Mr. Pathak, Learned Counsel for the petitioner. So this is what?
This is, we had made a request if a settlement can happen, so.
Out of court settlement, they are trying to make.
Mr. Pathak submits that he has an instruction that the respondent is ready to settle the matter out of court.
And accordingly, they have approached me, lord.
This, what is this?
This is the application that we have submitted to the appellants and the deputy commission.
Okay. Submitted.
Already submitted.
And submitted application before?
The deputy
These are
commissioner and
respondent.
NIPCO. The NIPCO and the deputy commissioner.
Okay. These are the appellant.
They are the appellants.
Okay.
And
1, 2, 3.
And submit and to that effect, already submitted an application on 26/5/2025. Okay. In this regard, Mr. K. Agarwala, Learned Counsel, Learned Senior Counsel, appearing on behalf of the respondent shall obtain necessary instruction. Okay.
Yes.
Appearing on behalf of appellant.
Okay, appearing on behalf of the appellant.
Appellant.
Sorry. Shall obtain necessary instruction. And apprise this court on the next date. Okay. Okay.
Lord, item 20. Lord, is connected to the same lane acquisition proceeding. My lord. A friend is appearing.
Item
20, my lord.
Item 20 is a CRP.
Okay, item 20 is
My lord, they have filed a reply today. We have received.
they have filed reply.
Today we have received, my lord.
What do you want? Yeah.
Government is yet to file. Whether the government will file or not, I do not know. But because the entire issue is that the deputy commissioner did not.
Mr. Sunil is for the petitioner.
Yeah, this can be
Okay, you
also
filed reply.
we have filed a rejoinder. So it can be also fixed for the hearing, Your Lordship.
It has not been admitted.
Admitted?
Not yet admitted.
Your Lordship may admit the matter.
Well,
It is for admission hearing?
On that day.
Okay. Mr. Learned Counsel. Okay. Heard Mr. Sunil Moore, Learned Counsel for the petitioner. Also heard Mr. Learned Senior Counsel assisted by Mr. Senapati. Okay. Who submits that he has received a copy of the affidavit in reply filed by the petitioner. No.
But they are the, my lord, petitioner. They are the petitioner. They are the petitioner. They are the-
And counsel for the petitioner represent and submit that he has
I mean,
received
respondent
a
number?
affidavit in reply filed by. Mr. Sunil,
Yes.
you have received affidavit in opposition.
Yes, we also filed
You
the,
have also filed.
we also filed.
Okay, you have received the copy. Okay, then.
I am praying for, sorry, I am appearing for respondent number 2.
Okay, Mr. So-and-so.
But,
Carrying on
respondent
the-
number 1 is Deputy Commissioner.
Respondent number 2, who submits that he has received affidavit in reply filed by the land counsel for the petitioner. On behalf of the petitioner staff. And Ms. Mongo, land counsel. Here on behalf of the respondent number? 1. Okay. Whether any record was called for, no? Record necessary? No, not necessary.
Admission of officer, let it be, my lord. Once it is admitted, your lordship will definitely call.
In this case, record is not.
Okay.
Well,
Record
but
not necessary.
a deputy commissioner can file affidavit if they want. to
Deputy
file.
Commissioner not yet
Yeah,
filed.
respondent number 1.
If it's necessary, we'll file, man. By next.
Their affidavit will be of, my lord, importance, my lord, because the ultimate.
In that case, you wait for the affidavit to be filed by the deputy commissioner, or will just list it for admission?
No, in the meantime.
In the meantime, they will file.
Yeah, in the
Okay,
meantime.
let this matter.
If they file in the meantime.
Let the
We can dispose in the admission stage.
On
also.
23rd
23rd, my lord.
July
I'll be here, so, my
for
lord.
admission. In the meantime, the respondent number, this is respondent number 1 shall file their affidavit in opposition. Okay.
Much
Okay.
obliged.
May I please?
Yeah.
Hello. This is a criminal petition. We are praying for a date to file an IA. Because recently we have received some document, a relevant document. So we want to brought that document on the record.
Lordship,
A week time we will file within a week time.
for that Lordship, for the respondent, I have an objection to that Lordship. That is a matter of trial, what my brother is saying, Lordship. The Honorable High Court has to decide whether the 20% in the interim compensation as by the Honorable Trial Court is tenable or not. Lordship, that is only has to be looked out. What my brother is saying, even if there's a document which is vital for that, that is the trial court has to look into it. The High Court has to look, with the order which they have challenged is 26/8 of 2024.
Because, my lord, in the trial court, we have taken the stand that GST account has been blocked. It's not open. Therefore, we cannot pay the GST amount. The farm GST account is due to non-functioning of the GST account. We could not pay. And that stand we have taken before the London trial court. And regarding that, the government of the chief engineer, PWD Assam, they have issued some certificate, and in the certificate, it is shown that the farm Purumpume Enterprises was valid up to 2019. Thereafter, it was not renewed, and because of that,
But see, after obtaining this interim is only, of course, with respect to the 20% check amount.
Yes, Lordship.
What is the proceeding of the case? It's going on.
The proceeding has, Lordship, after the trial court.
Proceeding was not stayed.
Proceeding of the
was
case
not
is
stayed,
going
but
on.
Lordship, the trial court was on assumption since the.
No,
in-
the order is clear. It's only with regards to the deposition within 15 days. That was. Yes.
That has been, cleared by this honorable court. The proceeding has not been stayed, and the next that has been given on September, Lordship.
Okay.
Yes, that may, Lordship, the the petitioner, they have come before this honorable challenging that interim. There's nothing to do, if they file a vital comments on that part, where
it appears that since then you are taking adjournment one after another day. So it will be difficult because only, or have you filed for the vacation of this interim?
No, Lordship, I have not filed.
No.
Yes, since Lordship, I'm not going into the merit of the case. Only the fact before this court, honorable court has to decide whether the interim compensation given by honorable trial court is tenable or not, whether that is as per law or not. That only has to be decided, Lordship. Nothing more than that one, because the trial fact of the case.
Now, what do you want to file? You said you have received some document.
Yes, yes. Recently, we have received some document.
not help the
What type of document?
That document says that the registration, the firm Kurung Kume Enterprises, the respondent firm, it is not renewed. And even before the.
What is that? What is the purpose of examining all those in this case? Whether that is to be examined?
Yes, because their GST account is blocked. Therefore, we could not pay the GST amount.
Mr.
T. Sunil.
Mr. Sunil, huh?
T. Sunil.
T.
So
Sunil.
that is a fact of the, that has to be only the trial has to look whether there is a case upon it's a case or no, Lordship. That is trial court has to examine. Lordship, only the issue before us.
Let them fight. One.
Lordship, that will not suffice their case. What the Lordship, honorable court has to decide whether that interim compensation was hard by the.
Whether any record was called for?
Lordship, record will not be necessary. Only
Not necessary.
Not necessary.
There.
Only Lordship, this is the impugn order which they have challenged. Lordship, may I take you to 77? This is only has to be decided by this honorable page 77, Lordship. Because of the fact of the case, that will the trial court will look into it, Lordship.
My lord, while hearing the interim compensation of the check amount, the merit of the defense case has to be taken into consideration. Therefore,
that also has been taken.
That document is very material for deciding.
If that is the case, Lordship, let this case be disposed of and let the matter be heard before the lower court. That also can be, Lordship, instead of keeping the case pending here, Lordship.
Yes, yes. I have no objection if this can be referred back to the trial court. Re-hear the 20% interim compensation of 2%, 20%.
And Lordship, going to the record, it says both the consult has been heard. It's not that there was an expertise.
No, re-hear on the question of
whether the
granting this 20%.
Yes, Lordship. That was the even this Lordship, this honorable court can also decide this matter whether if the 20% is it's tenable or not, Lordship. That has to be decided, Lordship. And then Lordship, in going to their pleading also, Lordship, they have received the 50%, more than 90% the bill from the contract work. So 20% is tenable, Lordship, in my understanding.
Okay. So
and Lordship,
at the time of decision of this.
And Lordship, what the negotiable instrument says, Lordship, even if in future, Lordship, in the course of trial, I lose the case, then I have to repay him with the bearing interest, Lordship. So there's nothing harm in that, Lordship. The view inserted under in the year 2018 was to, Lordship, since there's a delay tactics taken by the most in the accused person, with a view to address the delay tactics only, Lordship, this section 143A was inserted.
My lord, recently only we have received the document, and that is very pertinent, relevant in this case, because the Honorable Apex Court has held that while hearing the interim compensation of 20% in check bounce cases, the defense case, the merit of the defense case has to be taken into consideration.
Within 2 days. Okay.
Yes.
You filed within 2-3 days. This week?
No, 1 week. 1 week.
Mr. T. Sunil, Learned Counsel for the petitioner, submits that. When did you receive that document? You said
I have received the
during the pendency of this case. that record yesterday only through WhatsApp has received a document germane to the case, which he would like to bring on record by way of filing additional affidavit. The prayer is allowed. The petitioner is allowed to file and allowed to bring on record the documents by filing additional affidavit within a week from today. So, Mr. V. Jamalani, counsel for the respondent, is also present. So, list this matter next week. Okay.
Lordship, a fixed date may be given.
Okay, that when?
Convenient of my brother.
By both the parties. List this matter again on. So today is?
Today is 16, Lordship.
16. Then next date will be 25. Okay.
Can it be on 27th?
27 is Friday.
27 is Friday, Lordship.
26.
Deeply obliged.
Yeah, admission matter has come for admission. Allegation is only under section 506.
May I please, my lord? My lord, I am appearing for the private respondent. I have not received the copy of the petition, ma'am.
I have not yet received.
No, amicus curiae was appointed, my lord. We have served the copy.
Not
Amicus curiae was appointed.
No.
Oh, I'm sorry.
No, you are correspondent, private respondent number 2.
Copy. Do you want copy?
Okay, there is only private. Not yet received.
Not yet received.
You have copy?
Ah, yes.
Okay.
When did you appear?
Mr.
Today, he's going to appear today, my lord.
Okay, line counsel for the A.K. Purkar, line counsel for the petitioner. Stop. Also, Mr. P.A.T. line additional PB for the state respondent number 1. Stop. Mr.
M. Ratan.
Line counsel appear on behalf of the private respondent number 2 and submits that he has not yet received a copy of the petition. Stop. The petitioner shall furnish a copy of the petition to the line counsel appearing on behalf of the respondent number 2 during the course of the days.
My lord.
Within 2 days from today. Stop. List this matter.
On 28th of July.
Okay. Age prayer for comma. List this matter again on 28th
July.
Okay.
And interim, there's an interim order.
Stop. The interim order passed earlier shall continue till the next stage of listing.
Deeply obliged.
My lord, this matter is part heard, and it's a succession appeal. It's a succession appeal against the impugned judgment dated 14/10/2024
Just
and decree dated 24/10/2024.
Just a minute, Mr. Barton. So this is item 11. Who is for the respondent?
Respondent is outside, if I may call him. My lord, this is an appeal against the judgment and decree passed in title suit application number 02 of 2023. The entire crux of the matter in title suit application number 22 of 23 was who is entitled to receive the debt and benefits of the deceased Gocham Taga. Now, in this appeal, the brief facts of the case is that the petitioner, the appellant herein, is the first wife and the only wife of the petitioner, of the deceased. And the respondent number 1, who is Srimati Singh Dikhi, is claiming to be the second wife. And my lord, in this judgment is page number.
Who is the respondent number 2?
Respondent number 2 is the son, my lord.
Son of?
Son of deceased and me, and I, my lord.
Okay, this son of petitioner.
Son of appellant. Son of appellant. I'm the appellant.
Appellant, okay.
Yes, my lord.
And 3?
3 is also my son. 4th is the mother of the deceased. 5th is my daughter.
So the respondent number 1 claimed to be second wife doesn't have any children. No children.
Sorry, my lord.
With respondent number 1. Yes.
So, my lord, judgment is page number 26, my lord.
Page
26, my lord. The operative for in the issue, in the title suit application, there are 4 issues were framed, my lord. There is page number
32.
Page number 32, my lord. Whether the plaintiff named Srimati Rotamyama is the legally wife of the deceased late Gocham Taga, or whether Srimati Sheng Deki is legally wedded wife of the deceased late Gocham Taga. Number 2, whether the plaintiff number 2 to 4, namely Sri Timi Gocham, Sri Saktar Gocham, and Miss Pinky Gocham are legal heirs of the deceased late Gocham Taga. Number 3, whether the plaintiffs are entitled to get succession certificate in connection with debt and securities left by the deceased late Gocham Taga, and if so, to what extent?
Just a minute. The respondent number 1 is sharing
Dikki. There is the alleged second wife of the deceased.
Okay, so
my lord, in this appeal, we are merely confining ourselves to issue number 1. That is whether the plaintiff named Sri Romati Rotamyama is the legally wedded wife of the late of the deceased, or whether the defendant, Srimati Singh Deki, is legally wedded wife of the deceased late Gocham Taga. Now, the operative portion, my lord, is page 44, my lord.
Yes.
Pair 36, in view of the above decision arrived upon the foregoing issues, it is ordered that plaintiff number 2, Sri Timi Gocham, plaintiff number 3, Saktar Gocham, defendant Srimati Sheng Deki, and mother Yemi Gocham are entitled to inherit the debt and securities left by the late Gocham Taga in equal shares, 25% each. Now, we're merely disputing the 25% that has been granted to Srimati Sheng Deki. So, my lord, in this judgment, my lord, the learned trial court has on this document that is marked as annexure number 6, my lord. This is the last page 140. Page 140. This certificate has been relied on by the learned trial court to pass the judgment that Srimati Sheng Deki is the valid wife of the deceased. This is the certificate. This is to whom it may concern. This is to certify. Now, my lord, kindly peruse the document a bit more closely. It has no date. It has no certificate.
So this document?
Yes, my lord.
Issued by whom?
It's issued by. It's not a village authority as well. It does not fall under the definition of village authority as well.
Just a minute, sir. Oh, it says not a legal wife.
It says not a legal wife of late Gocham Taga, which is, and she is trying to conceal the facts and misguiding the court. We, the members of Gocham clan, Gaoburas and relatives, have strong objection against the adulterer Srimati Rotamyama, who is falsely claiming the service benefits of late Gocham Taga. We further certify that Srimati Sheng Deki is the legally wife of late Gocham Taga, and she is entitled to claim the entire service benefits of late Gocham Taga, who left her on the fateful day of 24 August 2020. This document, my lord, was surreptitiously brought during the trial and it has no date. It has no date, and this has been given legitimacy by the trial court under section 40 of the Assam Frontier Regulation Act, my lord. Section 40 of the Assam Frontier Regulation Act.
Just a minute.
Section 4. My lord, this document has been given legitimacy by the trial court under section 40 of the AFRA Act, my lord. Section 40 reads as follows.
Just a minute. Yeah.
Yes, my lord.
Okay. By this certificate, this was issued by the relatives of the deceased.
Yes, my lord.
And then declared that the petitioner left.
Yes, my lord. In the year 2010.
And then remarried to some other person.
No, my lord. That is not proven. That is not proven, and that's been noted in the
This certificate says, as per certificate.
Yes, my lord.
And then the respondent number 1 is the legal wife. Whether this certificate says something about the children?
No, my lord. This document was surreptitiously brought during the trial, my lord. It has no date as well, my lord. And the trial court has made a major mistake in giving legitimacy under section 40 of the AFRA Act, my lord.
No, you are aggrieved by?
We're aggrieved by
the decision.
By the fact that Srimati Singh Dikir, the respondent number 1 herein.
So, but by this order, the impugn order, the petitioner as well as the respondent number 1 has been given 25% each.
No, my lord, not the appellant, my lord. I have not been granted 25%, my lord. Instead of me.
This order, the plaintiff number 2. Okay.
Instead of me.
Your name is not there.
No, my lord, I have not been granted 25%.
Okay, just a minute. This is for children are there.
Children has been granted, my lord.
Okay, 3 children. And
mother and wife and the alleged second wife.
Second wife. Just a minute. How many respondents are there? Otherwise, there are 5 respondents. How many persons named?
In this.
Plaintiff number 2. Timmy is. Just a minute. Let me confirm. 2.
Timmy has been granted. Sakhtar has been granted.
Timmy, Sakhtar.
1, 2, 3, 4 has been granted, my lord. 25% each.
Timmy, Sakhtar, okay. 3. And mother, Yami. Mother, Yami. Okay, the Yami is mother of the deceased.
Yemi is mother. Number 4. We're not disputing as to the.
The respondent number 5 is.
Respondent number is the daughter, my lord, but daughter also has not been granted.
5 not granted.
Not granted, 25, and we're not disputing that, my lord.
Okay. You have no grievance against that.
No, my lord. That
So
we have
only
made
that
them
you
as.
Only that you have not been granted.
Yes, my lord. I'm not representing respondent number 5. Respondent number 5 is represented by.
I'm for respondent 2, 3, and 5.
2, 3, and 5.
And we have no objection on the
2, 3, and 5.
Yes.
And who represents the respondent number
4
and 1?
1 and 4 are not being represented, and
they are the necessary parties.
Yes.
1 is
service has been completed in the month of February, my lord. They're avoiding.
You're not disputing the 2 granting to 2, 3, 4, and 5.
Yes, my lord.
Oh, no, not 5. But then 1 is the main party.
Yes, my lord. Service was completed in the month of February, my lord. And in the previous last two, the court has, this honorable court has observed that service was completed and then the matter may go on ex parte, my lord. May proceed ex parte, and they're taking steps, my lord. They're very much aware of this proceeding that's happening here, my lord.
Maybe unable to afford. Maybe not in a position to afford.
No, my lord, they're very well to do. Very well to do, my lord. Respondent number 1 and 4, my lord. 4 is not necessary. 1 is very well to do, my lord. She's an officer of the.
The respondent number 2, 3, 4. You are also not disputing. They are also not disputing. Nothing. But then only the concern, the necessary party is 1.
Service was completed in the month of February, my lord. My lord, service was completed in the month of
You
February
want the
itself.
matter to be decided on merit.
Yes, my lord, it may be decided on merit, my lord. It was completed, and last two matter also for hearing. Only TCR was. We were only waiting for
It has
TCR.
also been called for.
Yes, my lord, it has been called for.
What we'll do is just one. They are entitled legally, legal aid council. They are women, tribal. What we'll do is we'll just one person, let person from legal services authority be represent this respondent number 1, because you have no dispute.
No.
Both of you, no dispute. You are also not disputing granting him, but then this one need to be represented.
My lord, they're very much well aware. They're not coming on purpose, my lord. They have received a notice on
Received the
February of
notice.
25. I have filed an affidavit to that effect, my lord. I filed an affidavit wherein services completed to them on February myself.
By what
Last one of
drastic?
February.
By which order?
By the last order as well, and the previous to that also, court has noted of that. My lord, she is the district transport officer, my lord. She has enough funds to represent herself if she wants to. She's not interested in this matter. This was part heard, my lord, in the last only trial court records were called for, my lord.
Okay. So what document you have to show that you were or you are still entitled? You are married to somebody, some other person?
That has not been proven, my lord. That has not been proven in the lower court, and even the judgment has accepted the fact, my lord. Even in the judgment, it has been noted that there's no evidence as to.
But came into conclusion.
Sorry, my lord.
But the trial court came into conclusion that you are married.
Only on the basis of this document, the document which has been annexed as annexation number 6, my lord.
Whether you have disputed this document.
Yes, it has been disputed in the cross, my lord.
But then it was even then it was admitted.
Yes, it was admitted, but it was clearly disputed.
Now you were given an opportunity to dispute, and thereafter also, even then.
My lord, kindly come to page number 114, my lord. Page number 114 of the petition.
What is that?
Cross wherein of the respondent number 1, my lord. The cross. Witnesses before this court as witnesses. It's a fact that our marriage, though our marriage was not
cross. 114,
my lord. 114.
14.
Yes, my lord. 114.
114 is continuation of the page.
Yes, my lord.
There
Kindly,
is
my
an
lord,
evidence.
I'll just.
It's 113, I think.
Yes, 113. No, 13, 114 is where I have. I want to.
13 is okay. 14, which one? Which para?
Para number, line number 1. 7, my lord. I cannot say whether P Exhibit 2 is a valid document regarding decree of
No.
divorce.
I think 113 is a cross examination of sharing Dekhe.
Yes, my lord.
Dekhe.
Yes.
Okay, it starts from 113.
Yes, my lord.
So which one you want to read?
114, line number 7, my lord. Of 114, line number 7.
Line number 7.
Yes, my lord. Page 114, my lord.
Yes.
I cannot say, I do not know whether Gocham Society has any right to declare legality of marriage, but I was accepted them as their daughter-in-law, sister-in-law. I cannot say whether P Exhibit 2. P Exhibit 2 is the annexion number 6 herein, my lord, is a valid document regarding decree of divorce. In order to prove P Exhibit 5, which is another document, but my lord, but here we have disputed, in even several other crosses, we have disputed, my lord. We have disputed, clearly disputed the document. Despite this, the Honorable Trial Court has noted that we have not disputed, my lord.
This document is PX
It was
marked as a PX2.
PX2, my lord.
What
And
is
it was
PX
considered
what
as
is-
a
what is PX5?
P Exhibit 5 is a loan agreement. Loan agreement that was not admitted, my lord. That was not admitted. P Exhibit 5 was a loan agreement, a photocopy of a loan agreement, but it was not accepted by the trial court, my lord, because the original wasn't present. My lord,
So the respondent number or the petitioner is your mother.
Yes.
That is why you have no objection.
No objection.
So she is not married to somebody.
No. As far as I am aware, no.
She need to appear. She need to appear. This
Who needs to
respondent-
appear?
Respondent number 1. Because you are mother and son. And she is the one.
Service has already been completed, my lord. Service has already been completed. She has been given enough time. February was when a service was completed. February, March, April, May. This is 4 months, my lord. And we can proceed without her, my lord.
Now you see, it has to go to that merit because we have to see the entire evidence, whether somewhere, anywhere, mention that you are married to somebody, the person, after leaving the deceased
Yes, my
in
lord.
the year 2010. So we need to go through the entire documents. So
Yes, my lord.
who will point out that? This court will have to go through, isn't it? Go entire documents, the evidence. It has to be then listed on for hearing.
Yes, my lord.
Because no one is there to point out this court that there is evidence stating that she was married after 2010, no longer.
But
staying
the
with-
court itself, in its judgment, has observed that there is no evidence, there's no documentary evidence or anything as to prove that she has been remarried to another after the death of the deceased.
But whether this person who has issued
Now,
this
only on the basis of the certificate, my lord, that is annexion
just a
number
minute,
6.
whether the person who has issued this certificate, saying that she is no longer the wife, whether any one of them have been examined?
Yes.
Who?
One of the.
Where was the certificate?
This is 140, my lord.
See, 1 to 7, up to there are 7 persons who have issued. All of them are the relative of husband, brother.
My lord, it's also it's a matter of also a question law, my lord. It's a matter of question of law whether this certificate is even if not disputed, whether this certificate of divorce.
Whether you have challenged or you have
We have
examination.
we have challenged, my lord, in the depositions of the cross of the other party also. It can be seen that we have challenged. It was orally also challenged, but and my lord, it's also a question of law.
Can we see just once the evidence of this 1 to 7, this person who have issued?
1 to 7 is.
And then if they have stated and if you have really demolished their evidence that.
No, they were not called for, my lord. They were not called for. These are relatives, my lord. They were not called. They were not called for.
None of them were called for.
Yes, my lord.
Then who exhibited this?
This was exhibited by the other party, by the defendant.
The respondent number 1.
Respondent number 1. And it was in the cross, it's clearly seen that it was disputed, my lord. It has been asked whether it can be treated as a decree of divorce. Because on the basis of this document, they were making the argument that
any of the children have been examined.
children, yes, my lord. Children has been examined. Children all have been examined, my lord. Children.
Any of the children pointed out that after leaving the father, their mother got married with some other?
No, my lord. No, they have attested to the fact that she's not remarried.
Because this certificate named the husband also.
Which certificate?
Yeah,
my
just a minute. Consumer so and so, wife of. Yes.
Yes, Sri Dorjika.
Dorjikando.
That is a fabricated. This is a fabricated document, my lord.
Whether
This is the fabricated document. There's no date as well, my lord. Look, kindly peruse the document, my lord. It has no date. It has no date and has been given legitimacy under section 40, my lord, of the AFRA. That is the major blunder that has been committed by the trial court, my lord. Major blunder, my lord. Section 40 under section 40 of AFRA, my lord. It has been given legitimacy. Now, section 40 also has to be.
Okay. What we'll do, this is in admission or order.
Admission, my lord.
Admission. What we'll do, we'll admit it and list it for hearing.
It was already admitted. Okay, my lord.
Admitted?
Yes, my lord. It was admitted.
Then why it has come again for admission? Because the.
My lord, in that case, my lord, interim may be considered, my lord. Interim may be considered. We have prayed for interim in interim. We have interim. The impugn order and decree may be stayed, my lord, and we can. And in the second order, my lord, in the second order that was passed in this matter, the honorable court had observed that on completion of the service, my lord, interim would be considered, my lord. Interim may be considered because there's yes, my lord. Even the previous judges noted that there's a prima facie case in my favor.
Okay.
And in this order, impugn judgment order may be stayed, my lord, and it may be fixed for another date for hearing, my lord.
Mister. You are Mr.
Mukbang Pertin, my lord.
Oh, you are also M. Patil.
Yes, my lord.
Okay, M. Patil, Land Council for the appellant. Also heard, Mr. Your name is there?
Yes, sir.
Oh, Mr. Gatso, T. Gatso. Land Council appearing on behalf of respondent number 2, 3, 4.
2, 3, and 5.
2, 3, and 5. 2, 3, and 5. Oh, you are not representing the.
Yes.
They are difficult. Mother and respondent number 1 excluded. None appears on behalf of the respondent number 1. 4, 1 and 4. Start. No, just where it says that the notice treated to have been complete.
In order, I filed an affidavit, my lord. I filed an affidavit.
Affidavit for what? It was a dusty service?
No, my lord. It was through registered post routed through the registry, my lord. And the screenshot of the listing has been attached, my lord. It is an order number 3, my lord, I think. If I correctly recalling, my lord.
Okay.
Kindly interim may be considered and may be granted, my lord. Because the previous judges also observed that My lord,
having regards to the contents of matter in the petition, the okay, the appeal is admitted for hearing. Stop. List is when? When? After 2 weeks. Okay.
yes,
In
my
the
lord, after
meantime-
2 weeks.
In the meantime, the operation, how it is affecting actually this?
It's
impugn order?
affecting only, it's affecting all the parties, my lord. The interim will affect all the parties. That's why the Honorable Court was going to dispose this matter of as soon as possible, my lord. It's going to affect all the correspondence as well.
Now this was passed on 24.
24, my lord.
So what is the effect of passing this order? Already
The debt and securities of the deceased would be granted to 25% each to all the 4 respondents. 1, 2, 3, 4.
so the property is with whom?
Respondent number 1.
Okay,
Only the
respondent-
25% that is granted.
Whether it's the benefit is also. No, it's nothing like that.
No, my lord.
Okay. The operation of the impugn order dated when it was passed 14
Oh,
10/2024 shall remain stayed.
and decree, my lord.
Huh?
And decree as well.
Okay. The operation of the judgment dated 14/10/2024 and the decree, where is the decree?
The decree is
Where?
It is annexion number. Annexion number 1 series. Page number 45, my lord.
Page 45 is the decree.
Yes, my lord.
This is order or application, page 45.
Page 45 is the decree, my lord.
Hmm?
Page 45 of the appeal, my lord.
This dated 29.
This was signed by the judge, but it was passed
24.
on 24, my lord. 24 October 2024.
Okay.
It was
And
signed by the judge on
and
29.
decree dated 24/10/2024 shall remain stayed. Okay.
Yes, my lord. Much obliged.
That is fine. Because you see, although the but then we have to see the records.
Yes,
For the purpose of disposal. Huh?
Right.
My lord, may kindly take up item number 22 along with item number 12, my lord. These are the connected matters arising out of the same judgment and sentence order.
Item number 12 and item number 22, Your Lordship.
20?
22. Your Lordship, in this matter, the TCR has come, Your Lordship.
This is
Appeal, Your Lordship.
Appealing is
paperwork necessary?
The TCR has just
TCR is there.
been received, Your Lordship.
No.
Your Lordship can direct for paperwork, Your Lordship.
Okay.
Otherwise, my lord, I have been convicted for a period of 5 years, my lord, for possession of 8 kgs of ganja.
And you were since, huh?
And on the last occasion, my lord was of the observation that this matter will be taken up in respect of the IA. Since the punishment is for a fixed period of 5 years. My lord.
Okay, then
I was-
how long you have been inside?
So as of today, my lord, I have been under custody for 77 days, my lord.
For?
77 days.
77 days?
Yes, my lord.
Long way to go.
But otherwise, my lord, there's every possibility of succeeding this appeal, my lord.
Okay.
That's the reason,
Okay.
my lord, I have.
We wish, but let us get this paperwork prepared. Okay.
Yes, Your
There
Lordship.
are a few other judgments of this honorable court wherein those punishments which are of 10 years also has been considered, my lord, and the IA has been suspended. This-
Just a minute.
And my lord, in this case, the appellant is a lady
How
of-
many accused?
There are
Two separate persons.
two separate persons. Yeah.
Okay.
the appellant is also a lady, my lord, with 4 minor children, my lord, on humanitarian ground also, my lord, as well as on marriage.
Convicted under
Under section 20 subsection under
B1
B2 and as intermediate quantity, my lord. For possession of contraband.
Okay.
Your lordship, yes, lordship. Your lordship can direct for preparing of the paper book and list this matter for final disposal after 3 weeks. Your lordship.
In that case, my lord, I have a small request, my lord. Some observation, my lord, on Monday, this matter may be fixed, my lord. And on Monday, my lord, the endeavor shall be made to dispose of the IA, my lord. IA, my lord, on Monday.
Your lordship,
kindly.
I'll be needing paper book to
Because
even
otherwise, on
go
the
to
last
the
occasion,
IA.
this
Your
honorable court has made an observation.
There's
My
nothing
lord
as
may
such in
perish the
the
last order.
order.
Plus, subject to the case of that.
Again, also registered.
Only 3 weeks time, your lordship.
Mr. J. Seri, Land Council for the appellant. Also, Miss Jeannie, Land additional PP for the state respondent. The trial court record has been received. Let a paper book be prepared. The registry shall do the needful and furnish copy to the parties stuff and list this matter after preparing the paper book and furnishing a copy to the parties. Okay.
At least next week, my. There is many.
List is okay. After preparing along with this 22, huh?
Yes.
Right.
Along with this criminal appeal 10.
Your lordship, even with the lordship, only 3 weeks time, because I'll be needing the paper book even to argue on the matter of giving the bail, your lordship. If your lordship then finally dispose it of after preparation of the paper book, final hearing.
My lord, there's no point of hearing the IA also.
Absolutely, your lordship. Your lordship may dispose of the finally
My lord,
dispose
since
of
there
the
are
case.
various by one. There's various authorities of Honorable Supreme Court as well as our Honorable Court, my lord, wherein the punishment is fixed for a certain fixed period of time. My lord, the IA must be taken into consideration, my lord. If my lord may allows me.
No, in the last order it appears that it was to be listed along with the IA only.
Yeah.
Okay, IA also list this matter along with the IA. Okay.
Deeply oppressed.
In fixed date, my lord, in case if fixed date in case, my lord, for the IA, my lord.
IA.
For the IA.
Along with the IA.
IA, my lord,
Because-
this can be taken up on next Tuesday, my lord. You know, the last
No,
occasion.
in order to consider this IA also record would be necessary again.
Absolutely.
Records TCR has.
And in fact, my
TCR
prayer is as simple as it is, your lordship. When the paper book is prepared, the whole case can be disposed of on final hearing,
We'll
your
do that.
lordship.
We'll do that.
Convicted
It won't
for
take much time.
For 5 years, my lord.
Only 3
Convicted
weeks time.
Only 5 years, my lord.
No, he has been inside. You say that only 77
Otherwise,
days
my
in
lord,
execution of the
From the
conviction.
TCR, my lord, I can justify that, my lord, the prosecution has miserably failed to justify, even to prove that the contraband was ganja, my lord. Even that does not fall within the definition of ganja, my lord. So therefore, on the last occasion, I have also prayed, my lord, and my lord was of the observation that the IA will be considered on the next date, on his own merit. Therefore, I'm praying, my lord, since
There is an order that this will be considered on merit after receiving the scanned copy of the trial court.
Yes, my lord, the
That is
TCR has
there.
been received, my lord.
So then,
But then, since the TCR contains some of the documents which is not in the petition itself, your lordship, I'll be needing the paper book only
Okay.
to decide even on bail, your lordship.
Okay, then-
Suspension, your lordship.
Mr. J. Sri counsel for the appellant, also, Ms. Jeannie, additional public prosecutor staff. The trial court record has been received. Jeannie, additional PP, submits that in order to advance her argument on the interim prayer also, she would be needing paper book. In view of the above, this matter.
On 30th of June, my lord.
Along with-
After this one, July, 30 July. Okay, 30 July, huh? By then it will be prepared.
Prepare, Your Lordship. Deep
Okay, the registry self, the registry. self-
After 13th June, July.
The registry shall prepare the paper book at the earliest and place it along with the IE also.
In item number 22, my brother is appearing.
Okay.
Item number
And
12,
item
12,
22, his name, your for petitioner.
Yes.
Okay, then in 22, his name replaced. Okay.
By the last week of this month, man.
30 July, Your Lordship. is it?
30 July.
30 July.
Deep-
July would be too far.
Because there is a
At least by
vacation.
the last week of June, my lord, if as per the convenience. Otherwise, my lord, that will be extended, my lord, after.
It is fine only, it appears.
Obligation. Leave you.
All right. Sorry. Rest at 2. Okay, when do you want to? After 1 week. You are Mr. On the prayer of Mr. K. Para. Planet Council for the Planet Council appearing on behalf of the petitioner. List this matter. Next week. When? When do you want? After 2 weeks. Okay. Okay. Huh? No, I need to last. No. Statement recorded. Or executed also. What is the offense involved? Okay, 332.
Yeah.
Also. 3 PDPP Act.
Yeah. Only section 3 of PDPP Act, the imprisonment punishment is for up to 5 years. This is only non-bailable. Otherwise, both offense under 3 and bailable. Only section 3 of PDPP.
You have the status report. Yes, my lord, the status, the CD doesn't contain, your lordship, the statement of the accused, your lordship, and I have communicated the concern OC. I have been informed that because the investigation has been carried out by some other IO, and since he was on leave, the statement was recorded with the other IO, your lordship. Okay. So But then because it was of that, recorded. yeah, it was recorded, but it doesn't come in the, it is not the part of the CD. Okay. So Well, what execution of the bail bond is there on record?
It's not there, my lord.
It is also not there.
Yes, your lordship. So my humble prayer would be, your lordship, let this matter be listed again on 19, so that enable us to produce the updated case diary.
19?
Yes, sir, Thursday.
Oh, this starts there?
Today, yes, this Thursday.
Okay, you are protected by the interim order.
Yeah.
Okay. Okay, hard, Mr. K. Lowland Land Council for the petitioner, stop, Mr. Ete. Land Council, Land Additional PP, submits that. The IO is stated to be on leave. On
Yes,
leave.
he was on leave, lordship.
Okay. Well, he's stated to be on leave, due to which he could not receive the updated case study. Therefore, pray for listing this matter again on Thursday.
Yes, your lordship. On 19th.
19, okay, 19. Okay. List this matter again on 19. On which date? the BP shall obtain updated.
Case diary, yes, along with the statement of the accused.
Produce the updated case diary along with the statement of accused.
Yes.
Okay.
Oblige, Your Lordship.
Okay, the interim or the partner they shall continue till then.
Yes, oblige. Arising out of same FIR.
Okay, 13, 14, 16 also?
No, 15 different.
Okay, 14 same order.
Oblige.
Okay.
And currently my lord use various channels and covered on we say that my lord, the proposal was available to the wife of the by one Bidi Gumja. Gumja is my lord alleged to have the connection with some extremist group, my lord. NS, I think my lord, NS City, my lord, National Socialistic Council and Tiniland, na? Taniland. And he was arrested and he was put behind the bar, and on the basis of his statement, some other
Who was arrested?
My lord,
under the
Lordship Biro Gumja Tamil. Biro Gumja Tamil, he made a statement, and on the basis of his statement, some other persons were also arrested.
Biro Gumja.
Yes. Now the question, my lord, raised a question for myself. Even if there is any statement made by during the course of
this present accused applicant was arrested based
no,
on
he was not arrested.
Okay.
He is
So based on his statement.
Anticipatory bail. Some revolver was recovered from his residence.
Okay, based on the statement of Biro Gumja, and the police has visited the place.
That was the query made by your lordship. Whether on the basis of statement made by Biro Gumja, my lord, revolver was seized from my residence.
Okay.
And PP was, my lord, requested to obtain instruction.
Yes.
During the course of virtual court. Therefore, my lord,
Lordship, updated already submitted before your lordship on two occasions, lordship.
Otherwise, my lord,
third time, lordship.
Right. Otherwise, my lord, there is no any allegation against me. I am not a name against person. And I made a defense case that, my lord, Biri Gumja is the maternal uncle.
Earlier you submitted incomplete. Okay, now the complete. This is the complete one.
Yes, lordship. Updated CD, lordship.
Updated CD.
Yes. On the last token, lordship sought the statement of this Biro Gumja Tamil, but
okay, where is that?
His statement was not recorded, lordship, because he was
arrested.
Yes, he was arrested, and he is in the judicial custody, lordship. So I will seek 2 days time for police custody.
Because
in order to record
question, my lord.
Just a minute. He was arrested, but his statement was not recorded.
Not recorded, lordship. And police sought 2 days.
What police was doing?
IO, lordship. IO remanded.
What IO was doing after his arrest? He not yet recorded when he was arrested. Otherwise,
he was arrested on lordship
long before.
Here in this case,
two lordship.
Two.
One is Biro Gumja Tamil, other is Tapa lordship.
Now, what investigation he had carried out unless, he has not recorded the statement of the accused, arrested accused till date?
Since he was in the judicial.
What is there in the
he-
CD?
He was in
Kindly-
the judicial custody, lordship, so.
No, unless he was arrested, unless he was under police custody, how he was produced? How directly the judicial can arrest him?
Yes, please. And I made a.
He was arrested by the IO only.
Yes, lordship.
He recorded the statement. Thereafter, only it was produced. He was produced before the magistrate, and magistrate has remanded him
Yes,
on his prayer only.
yes, lordship.
Where is the statement?
The I said that the statement was not recorded, lordship.
Statement was not recorded.
Yes.
On what basis he is inside then? Hmm? On what allegation?
Since he is the armed dealer, lordship, illegal armed dealer.
Maybe,
Yes.
whosoever may be, but then after arrest, why he did not record? Call the IO.
Yes.
Hmm? He need to tell
Yes.
what investigation he has conducted. Let us see your case diary then. What is there? Unless he has recorded the statement.
Because that is the middle question.
In column 12, lordship, the
This one?
yes, lordship.
What is the source of information, my lord? And my lord was pleased to raise, my lord, make a pinpointed question, whether it is on the basis of statement made by accused or on the basis of some other information. Because we put on record our defense case. Because Birit Gumja is the maternal uncle of my wife. Someday, my lord, one day he came and he asked the wife of the petitioner, you keep it
Now,
in seal cover.
now you say
My lord.
that on the basis of the statement of Biro Gumja,
I don't say, my lord. My case is that
your house was
house was raided.
raided.
Right.
And where is that statement? Where from do you know?
It is his statement only,
Yes.
lordship.
Hmm?
But it is his statement only that
Yes.
I read them, but
No.
in CD.
Where from you are saying that on the basis of the disclosure statement given by the
Yes.
co-accused, your house was raided? We must have given some statement only.
Yes, I made it.
Don't tell me like that. Ask IO telephonically
Positive
also
statement we made.
whether he has recorded a statement of the Biro Gumja or not, because
In the CD, lordship, I said that his statement was not recorded, lordship.
No, my lord, Lordship kindly,
platform he is submitting.
Lordship kindly have a look, my lord, paragraph page 55 of the petition. There is a production report. Production report says, my lord, 1, 2, 3, 4. Last and the fourth line from bottom,
Page
page 55.
55.
My lord will be pleased to see. May I read, my lord?
Yes, yes. Which one? Para?
Last part, my lord,
Yes.
bottom.
Hmm.
Accused Biru Gumja Tamin was examined
See.
while in police custody
Hmm.
in connection with Itanagar PS case number 6 of 2000.
Yes, then what is this?
And already he was examined, and my lord,
He was examined only. What are you submitting?
and whether his statement was recorded or not, the PP is the best person to say. And whether on the
Mr.
basis of
PP?
his statement,
This is different. This is different FIR, lordship.
Hmm?
now
He
connected.
is seeking bail application on
This is
in
No, just a minute, just a minute.
PS case number 72.
Connected case.
Another case, lordship.
another case.
Yes, lordship.
Both are connected.
What is this PS?
There
What is the
are
PS case?
two FIR, lordship.
What is the PS case number? This which the applicant is seeking anticipatory bail. In which PS case?
In 70
We are
PS
We
case
are
number
taking
70.
privilege of my lord, privilege bail in connection.
You are seeking anticipatory bail in which
in
case?
connection with
72.
72.
Just one.
72.
72.
Right.
But then this statement was given on, recorded on 6.
Madam, both are connected case, both are allegations, same allegation. Connected with my ban organization, an arms dealer, peddler, extorter, what not, my lord, same allegation.
Okay, just a minute. This probably in the statement,
My lord,
while examining on the, in the PS case number 6,
my lord,
he has, it appears that he has a name,
my lord,
gave a disclosure statement,
my lord.
giving the name of the present accused. And then subsequently, probably this 72 was registered.
Whether,
Then by then,
right,
by the time it was registered, I think he was under judicial custody. Even then also the IO should have actually made a prayer before the court to record his statement. Why he did not make such an application?
Recording procedure.
Now, do you have the statement of the of this Gumjat Amin in PS case number 6?
Yes. My lord, Lordship, kindly have a look, my one more page, my lord, 56. In connection with the earlier case, Janavar PS case number 6 of 2025,
which
revolver was recovered. Second para. Page 56, second para.
One more illegal.
One more illegal firearm was seized from Amandugi. Amandugi is the son of. Therefore, both the cases are connected.
Okay. Of Karandugi.
Yes. And my lord, if it is a case that statement, my lord, I was source is the statement of the accused, then I will argue, my lord, advance my argument on this point. Because while considering the previous bail, court is not in a position, court cannot consider the statement of the accused person. Law is well settled by Supreme Court. That's why, my lord, court has to be confirmed.
You are
whether there is any
Karandugi.
Yes, I'm on the basis of statement of the accused, whether it is justifiable on the part of the court to consider the matter of prayer for bail. Supreme Court says no. I will satisfy your lordship. Therefore, my lord, court requires or court wants to know whether there was any statement made by the accused.
So, what are the articles recovered from the present applicant? Two
Yes,
illegal
my lord,
foreign.
we don't know what is what.
Okay, this is total. This is only total. Total seizure in the referred case. 2 illegal foreign made firearms. 32 numbers of live rounds. Case amount also received from recovered from your possession.
Tapa is a different accused person.
Different?
Different accused.
Okay, from you only.
Only, my lord, seal packet. That is our stand. Police recovered one firearm, so we don't know, my lord, what inside the bag. He requested and we kept the bag. That one police came, police took it away.
So probably you have.
And he is a minor, my lord, the son of the petitioner.
This is in connection with the PS case 72. Production of arrested accused. This is in connection with 72 only, not 6. And we are dealing with the PS case number 6.
We are dealing with 76.
So this is also 72. Forwarding of case diary or status of this is also 72. Yes, Lordship. So, but then we have called for the case diary in connection with the PS case number 6 only. No, it should be. Why you have produced it should be of 72, Lordship. It should be of 72. Which one? The updated series should be of 72, Lordship. 72? Yes. Since the applicant is seeking interim bail from 72 only, Lordship. 72? Not of 6, Lordship. Okay, sorry, this is 72. Yes, Lordship. Okay, statement was given on 6th.
Yes, Lordship.
Okay.
Otherwise, there would not have any question on how to recover, or to raid the house and recover the revolver. There must have some statement in connection with 6.
Petitioner, sir, Lordship, applicant says that it was seized from house, but as per the statement of IO, the son of this applicant surrendered before the IO, Lordship, in the police station.
Which one?
In the 17th, Lordship. There is Caesar list also, Lordship. Caesar list and 161 or 180 of Lordship. Statement, Lordship.
Madam, that statement does not reflect in the production report. Production report is absolutely clear. One more illegal firearm was seized from Amanduge. It is nowhere mentioned that he went to police station and handed over.
It was in the statement of.
And whether on the basis of that statement, court can reject my prayer.
On his father's instruction, Lordship, Amanduge surrendered before the IO, Lordship. Amanduge, the son of this applicant, Lordship. The son of this applicant, present applicant, surrendered the firearm before the OC IO, Lordship, at PS, Lordship. The statement is there, Lordship. The yellow.
What is the name of the accused applicant?
Karanduge, Lordship.
Karanduge.
Yes, Lordship.
Now this is the statement of. Okay, Tabanung.
The statement of son was recorded, Lordship. Who surrendered before the IO, Lordship. And Caesar memo is there. The yellow flag mark, Lordship.
Okay, when this case was registered? This present case.
FIR was lost on
FIR
was lost on 3-5.
This case?
39.
Type copy is at page number 42, Lordship. Type copy is at page number 42, Lordship.
But this is FIR.
Yes, Lordship.
FIR doesn't disclose anything.
Type copy is at page?
At page 42.
42. This was registered as?
72. Itanagar case number 72.
Okay, 7225. So here, where is the in the FIR? He is not a name FIR.
No, yes. It's not a name FIR.
Just a minute. Then on what basis it was housed? It was initially registered against whom?
It was registered against
Biro Gumja.
Yes, Biro Gumja.
So Biro Gumja otherwise is inside the custody.
Already inside.
In connection with
yes, earlier case.
And in the second case registered against him.
Yes, right.
And in this, while giving statement under in connection with that earlier case,
right,
he has revealed the name of this present accused.
My lord.
Okay.
And whether it is safe for the court to, my lord, rely on that particular statement while considering the anticipatory bail. And paragraph 39 of the latest decision of Supreme Court Supreme Court says it is absolutely, my lord, unjustified. No court can rely on the statement of the co-accused.
Yes, that is true. But then here is the case where he has himself or through his surrendered
That is
the
their
arms,
statement.
surrendered the arms.
It is
saying
their
that it was an,
My lord, it is their statement.
at the direction of his father.
My lord, it is their statement.
Their statement.
Their statement. Because son is the minor, ultimately, my lord, whether this statement of this son, minor son, how far it is reliable, my lord, this is another question.
Sorry, not minor lordship. His age was recorded as 27 years old lordship.
No. Earlier order of the court, it was recorded by earlier order of the court, because out of reasonable apprehension, I approached the court, before the session court, I applied for in connection with the earlier case, and interim bail was granted. And in that case, it was recorded that petitioner is having 5 children.
Petitioner is having 5
minor children.
Okay, but then the son is
Now he is saying, 29 years.
okay.
27 years. Whatever it may be, my lord.
That is for the purpose of bail.
And Supreme Court said, my lord, if the court wants to, my lord, reject the bail application, then court must have some independent evidence, my lord, incriminating evidence. And parameter was laid down by Supreme Court. There are 6 different conditions. If we want to rely on the statement of co-accused, these are the 6, my lord, preconditions. Those preconditions are to be satisfied. And that too during the trial, not before, my lord, pre-trial stage. So she may look into the judgment. Very, my lord.
Para 39.
Para 39. May I read, my lord?
Yes, please.
The High Court has its own understanding of Section 30, because statement is made under Section 30. If he implicated me, then it must have been under Section 30 of the Evidence Act. It says that what is admissible under Section 30 can also be looked into at the time of considering the plea of anticipatory bail or even regular bail. However, we are not impressed. That was a submission made by the learned counsel. We are not impressed with the views expressed by the High Court. We are of the considered opinion that such a confession, if any, cannot be looked into at the stage of anticipatory bail or even regular bail. Or
Yes,
the following
that is true. But see, we are concerned with this FIR.
My lord.
But nowhere the statement of the
accused,
Biro Gumja,
my lord,
probably is revealed. But then is before or after the surrender of the arms by the son?
My lord, kindly see.
The son doesn't know whether his father was whether Mr. Sri Biro Gumja,
my lord,
accused in 6,
my lord,
has revealed or not. But then son came voluntarily, it appears.
My lord.
And they deposited or surrendered the
my lord, with all respect, my lord, with all respect, my lord is absolutely right. She cannot go beyond the records. My lord, what is the allegation made in the production report? On the basis of which, my lord, ultimately a raid was, my lord, conducted by the police. Nowhere it is reflected that the son went to a police station and at the instance of petitioner handed over.
Probably the son has also given statement. Let us see the statement.
That was subsequent statement. That was a subsequent statement.
Yes, subsequent statement.
Already it was recovered.
His son would never give any statement against his own father. Let us see.
Well, otherwise, there would have been a reflection in the production report. Because revolver was already recovered.
Let us see if there is a statement of his son. Do we have?
No, I don't have. We don't have the copy, madam.
Son?
I don't know what is
the yellow one, lordship.
Yellow one. Son's name is? Amandugi. German Swin, so. He received a phone call from his father. His age is 27. clearly reveal the description, everything,
Madam, what is, madam,
where it was kept concealed.
Madam, may I just, madam, know, madam, what is the date of
Just a minute.
recording the statement?
He specifically instructed me to produce the said firearms after giving all description. The son stated that his father specifically instructed by telephonic call. And upon his instruction only, he took the said.
Madam, what the instruction, my lord?
And the
Also,
timing also, he clearly given firearms.
what the instruction also says, my lord, that he is involved in, my lord, unlawful activities or connected with.
That he has not stated probably.
And at the same time, lordship knows, my lord, lordship is quite experienced. My lord, defense case has also to be considered into, my lord, by the court.
Yes.
What is our defense case? We said Biro Gunja is closely related to us. And he came to our residence, asked, he is nice to just keep it. I will take it back. In the meantime, police came, my lord, after 2-3 days. Why that part cannot be considered, my lord? Defense case cannot be considered.
That is to be decided at a time of.
No, in the bail petition. I'm talking about the bail. Defense, if any defense case is put on record, then court is to consider the defense case. That cannot be altogether, I may not ignored.
Now, you give statement before the police.
Police, according
And
to statement.
police will examine, cross-examine.
Police is always, that's why Supreme Court says.
In interrogation.
Right, my lord.
Things will be revealed. You give a statement before the police, then appear regular bail.
My lord.
File regular bail for release.
My lord, after all, my lord, this son, my lord, whether son has acted according to instruction of
That
the
is why
petitioner.
you need to appear before the police and give statement. Like
Then
why?
some interim protection may be given, I will appear, will record our statement. Basic question is whether I have any connection with the, my lord, unlawful organization.
Okay, anyway, I'll pass order. Now I've understood. I'll pass order. Okay.
Now, if lordship wants to.
Bail rejected. He's not entitled.
My lord.
Detail order I'll pass.
My lord, lordship, kindly assure one thing, my lord.
Yes.
Yeah, the basic question is whether there is any connection with the ban organization. Whether there is any, my lord, materials.
That will not concern now because the police has to prove whether he is.
Because this is the basic allegation. This is the allegation of the FIR, my lord. They are connected with, my lord, ban organization. Therefore, that part of the materials is necessary.
Now that whether he is connected with the ban organization or not, Biro Gumja is the members of the ban organization. Whether the present one.
How the revolver has come into my possession, that aspect cannot be overlooked.
That is why, but whatever may be, but it was delivered by your son. Probably there is no instruction. The son has also not given any statement that these arms.
May I just take your
with my father was asked by Biro Gumja to keep it, and that is why I am delivering it. He did not say that also.
My lord, may I just take your lordship, my lord, at page 51? Because bail was granted initially, my lord, in connection with our, my lord, PS number 6. And what is the findings of the court? Page 51.
This is bail of?
Bail of, my lord, petitioner in connection with 6. Allegation is common allegation.
Present petitioner?
Present petitioner.
This is also anticipatory bail?
That is also anticipatory bail.
Granted?
Yes, interim bail was granted.
That is in 6?
Yes. And what is the findings of the court? I have my para 5.
Yes. I have carefully perused
the records of the case and found that the present case is initiated against the organization of national so under so. It is alleged that the said organization is carrying on illegal activities to wage war against the nation by recruiting the person and procuring illegal arms and ammunition in the soil of Myanmar. It is found from the record of the case that IO has already submitted charge sheet against 2 accused persons Tanahashi and Kachi Bidhu. Whereas the investigation is still undergoing, and other accused person, namely say Viru Gumja, Tapin Sanso are arrested in the case. It is seen from the bail application that accused Viru Gumja, Tamin, might have alleged involvement the accused person in the case to save himself. So might have, my lord, he implicated. Therefore, if there is any statement made by accused, that party has to be excluded while considering the bail application. That was the matter of observation made by the court, and court, having due regard to that observation, my lord, Lordship may reconsider our prayer.
But that was before that, before recovery, before surrender of the arm.
No, at that point in time, revolver was recovered from me. At the time when we approached the session court for obtaining, it was recovered already. Because production report was already submitted. Production report shows that it was recovered. And thereafter he approached. That order was passed on 17/5.
Then if after that, if the Lionel Session Court has granted bail to you, why you did not apply before the Lionel Session Court? Why you did not approach the Lionel Session Court?
It is the privilege of the petitioner, my lord, because High Court have the
Lordship, the applicant deliberately not annex the bail final order, Lordship, which speaks on 21/5/2015.
What is the final order in this?
Maybe, Lordship, the bail was rejected, Lordship. This is not annex the order dated 21/5/2025, Lordship.
That could be
Page number 53, Lordship.
What is the final order? Rejected?
I have rejected. I made a statement. I made a statement.
Saying what?
Saying that bail was rejected.
Okay.
Because of non-prostitution. Because of non-prostitution. He freed because of subsequent case.
Okay.
We made a statement there when he was about to go to police station. The advocate may not intimidate him. One more case is registered against you. Possibly you will be apprehended. Then he freed away.
Okay. Now he understood.
Now
He understood. Okay. Anyway, I'll pass on. Okay, hard Mr. Podcaster, Lani counsel for the petitioner. Also hard Mr. Loy, Lani PP. Okay. Detailed order will be passed. Okay. Item 15.
51 minutes, they made a prayer in the morning for adjournment. So I have no objection.
21.
21.
No objection?
No.
Okay. Who made a prayer?
Your Lordship.
Okay.
On behalf of Ketama, Your Lordship.
21. Just 21. So, can copy of the TCR received here. Who is you are for a petitioner? Okay.
Your Lordship, I'm on behalf of Ketama. He has been appointed as an LAC in this case. He has been appointed as an LAC and he is representing respondent number 2. So,
your prayer is?
On his behalf, like I'm making an adjournment for today. Since on the last occasion we have called for a TCR which has been received, Your Lordship, as per the case record. So, Madam, may we for admission hearing in that case.
This is criminal petition. Okay. Mr.
J. Sri.
Land Council appearing on behalf of Mr. K. Dama, Land Council for the respondent number 2. He prays that he submits. Okay. He prays for adjournment of the matter. On matter is what happened to Dama?
He is not available today, Your Lordship.
Okay. he submits that Mr. K. Dama, due to his some personal difficulties, court today, therefore pray for adjournment. Stop. Mr. Pulkastia, non-counsel for the respondent has no objection. You are also, okay.
I'm for the state, Your Lordship.
Okay, Ms. Jeannie, non-counsel for the state respondent is also present. He is prayed for by the non-counsel for appearing on behalf of the respondent. The matter stand adjourned. This matter again, when do you want?
On 28.
28, okay.
For admission hearing.
For admission hearing, huh? Stop. Okay.
July. 28 July.
July. July 28.
Yes.
Rashid, can you take up item number 17 first? Item 17, the petitioner is the prime accused. On 21st of May, your lordship was pleased to grant the interim bail.
Item 16?
Item 17. Your Lord.
17?
Yes.
Or 16, 17, sir?
Yes.
Now, you want me to see the 17?
Yes, sir. 17 is the prime accused.
17?
Yes.
Lordship, 16, 17, 18.
71.
Arising out of
Yes.
same FR, Lordship.
71, your lordship was pleased to grant interim relief on 21st of May. Thereafter, I appeared on 2nd, 9, 10, and 12th of May. 12th of June before the IO, and my statement has been recorded.
Statement was recorded.
Yes, sir.
And then what happened? Whether you were soon arrested?
No, my lord. My lord, shockingly, a personal bond was taken in favor of the CGM UPI, 50,000, and I was allowed to go.
That is bail only. Soon arrested and allowed to go. What the CD says?
Allegation is regarding embezzlement of money, your lordship. And the last portion of the FIR specifically states that since I am not to be found, that's why he preferred the FIR, because the recovery is impossible. Now that I'm available, I'm cooperating. He always have the
He's
option of-
cooperating. What,
No,
what is the
Lordship,
status?
Not exactly cooperating, Lordship, though he was arrested and released on bail, Lordship.
But he is appearing before the eye of the case.
Yes, Lordship.
Okay.
But he is not disclosing or Lordship.
Disclosing is different.
Lordship,
But he is appearing.
Yes,
Hmm.
appeared.
What do you want him to be disclosed?
No, that appeared, but he was engaged, he was using that money in other business, Lordship. It as proceeded, Lordship.
Other business?
Money was used other business also, Lordship. I objected the bail, Lordship.
So what?
It's a civil
But
nature.
then, but then he is cooperating, he is appearing before the eye of the case, giving statement, giving all his statement already. You want to say something?
On who?
You want to say something against himself? Want him to say something, give statement against himself?
Serious, Lordship, the money was invested in other business, Lordship, but.
What is the allegation?
My lord, kindly come to page. The allegation is embezzlement of money of 1,69 lakhs or something amount. And
who were you? Who are you? Otherwise,
I was an employee of the informants company.
Okay.
Manager, Lordship. Manager of this GG Consumer Goods, Lordship. And he transferred the money to his wife and his brother, Lordship. Applicant number in item number 16 and 18, Lordship.
Okay, he did not know earlier. He did not know. The last one. You were working as a manager.
The allegation is I was working as a manager, but I was a clerk. I was a clerk in that establishment, madam. In that establishment.
Have you shown your any appointment that you?
No, it's a private company. There's no appointment letter was handed over to me.
In private company, also for the purpose of getting salary, you must be, there must be some designation.
My lord, I don't have any documents to show my designation.
Then you.
And if your lordship would kindly come.
If there is no document, you can also say that I was not an employee.
No, I'm saying I was an employee. My lord.
That is why. Where is the any document showing that you were Because maybe I got maybe anything, salary slip,
My lord,
anything.
this
How
not-
long you were there?
My lord, I was there for a couple of years, my lord, but
Then
I'm
some
admitting,
documents-
my lord, I'm admitting that I was an employee. I'm only saying that I was not in the post of manager. That is all. I was an employee, and if you're
No,
not,
no, you were in the post of manager unless you show that you were not in the post of manager.
Otherwise also, if your lordship would kindly come to the last paragraph of the FIR, page 17. Last paragraph of the FIR, page 17, your lordship, if I may read. That he has cheated with criminal intention for his personal benefit by submitting correct data amounts in my office, which faces huge loss to our business. The sole intention of Sri Padma Bora manager was to deceive the consumer and flew away from Arunachal Pradesh without informing me and office staffs of the GG consumer goods. Sir, being the businessman, this amount needs to be recovered, which I could be able to run my business again. Therefore, I have contacted him, but I can't trace him out, and also tried to ring him several times, but there is no answer. It is also learned that the embezzlement amount has been transferred to the accounts of his elder brother and my wife. Josna Kosh is item number 16, and she has been granted interim protection, your lordship. Now, the nature of the allegation is of civil nature, because lordship would see wants to recover the amount from me. For that, the civil court is there. He is there. He has all right to file a money suit. I was not available. Now I am cooperating.
Whether any notice was served upon you?
Yes, your lordship would kindly see at page
You have annexed?
18.
Where? 18? What it says? Notice was by the owner.
This notice is from the police.
No, this is police. By the owner, your employer.
No.
No.
No notice from the employee. From the employer.
This is under 408. It's a breach of trust only, not a cheating event, huh? Then who are the others involved in what? This
My lord,
120B also?
My lord, Josna Kosh is my wife.
He or he
No.
Was also an employee?
No. So 408 doesn't apply upon her, your lordship. And
Yes,
120B,
that is what I'm saying.
Yes, 120B will apply, but 120B in respect of her is billable. Even in my case also it's billable.
Okay, but okay. So anything to submit? We'll make it absolute. Yes.
I'm appearing victim, my lord. I have the objection, my lord. Now, my lord will see, my lord.
You want him inside? No, you want the accused to be inside?
Law says
Kept
so.
inside.
My humble understanding, law says so, my lord.
Okay.
My lord is seen, my lord. Petitioner is trying to categorize this as civil dispute, my lord. Now, my lord, now 420 and criminal brush, two different things, my lord. If suppose the allegation of FIR, my lord, was that I lead him a money, my lord, under some deception, my lord, that would be a civil nation, my lord. Here is a case, he was interested in the property, my lord, our company. Now, without any authority, without any consent, my lord, he has the misappropriated that, my lord. So there is no question of civil case arising in this case, my lord, civil recovery, my lord. Now, my humble submission would be, my lord will consider.
Where is the allegation which contains the ingredient of cheating?
Not sitting there. That's why I say, my lord. I am saying, my lord, this is not case simplicity sitting, my lord. It is a case of misappropriation of money, my lord, by the person who is interested with that money, my lord. Therefore, my lord, this is not.
Have you given notice to the accused that this was under your
No, my lord. When I did not authorize him, my lord, when there is no question of giving him a notice, my lord, this was done without our knowledge, my lord. Have it that I have authorized him, my lord, somewhere indirectly or directly, my lord, that in such situation I have sent him a notice by recovery, my lord. It is a case, my lord, he has without any authority, my lord, has misappropriated the company money, my lord. There is no question of notice, my lord. Therefore,
let us see.
my lord, if FIR is clear, I believe, my lord. Therefore, my lord.
Let us once see 408. Let's see. IPC. So he was working as a manager.
Manager. Therefore, my lord, my first and foremost humble submission before this, my lord. My lord would not consider this bail application a normal bail application, my lord. This is a situation, my lord, wherein, my lord, person was entrusted with a property, my lord, of the company now. Now he has misappropriated all those money, my lord. Now the situation here is, my lord, that 12 family, my lord, dependent on this company, my lord. Now in the situation of vagrancy, my lord, destitute, my lord, due to his criminal act, my lord, 12 suffering, my lord. Now business is in verge of collapse, my lord. So I, my lord, categorize, my lord, this offense, my lord, by the petitioner, my lord, applicant, my lord, is a economic offense, my lord. Even if not economic offense, my lord, this is akin to economic offense, my lord. Now, when it is akin to economic offense, my lord, not a law, my lord. In the law of bail, my lord, in economic offense, my lord, Supreme Court has category of time held that, my lord, the AB, my lord, cannot be a, my lord, cannot become a license to commit the offense, my lord. In the such economic offense, my lord will consider, my lord, whether there is a incriminating material against him or not, my lord. If that is there, my lord will not grant the bail, my lord. In economic offense, my lord, the law of bail reverse, my lord. Once, my lord, police say, my lord, there is incriminating material, my lord, the law of bail is reversed, my lord. He need to prove, my lord, no, that was not committed by him, my lord. And until that is not done, that burden, my lord, is not discharged, my lord will not grant a bail, my lord. So what I have heard from the PP, my lord, it is saying, my lord, he is not cooperating, my lord.
Yes, what the CD says.
What I heard by CD says, my lord, he is not cooperating, my lord. The property has been invest in some other business, my lord.
What so needs to be cooperated because it's a calculation only. If the calculation,
That way, my lord, I humbly submit, my lord. My lord is considered not as a decision normal bail application, my lord. It is akin this is a
because in the calculation you have to show that this much of amount is missing from this.
Yes, my lord.
Then only, so what cooperation is necessary here?
No, but
if he is cooperating, if he is appearing, and then from your calculation only it will be clear that whether he has whether he has this one committed offense under section 408 or not, isn't it?
Yes, yes.
Now from the calculation itself, whether have you done that?
Yeah, now my lord
whether that was checked and found that he has really committed the IO. Where they found?
Yes, in
Where
pink flag, Lordship.
Pink.
Just of the pink flag.
Yes. Okay, the elder brother was also the employee.
Yes, Lordship. And the green mark flag, green flag is the reason why his custodial is necessary, Lordship. Custodial inquiry is necessary.
Elder
Lordship.
brother so and so has deposited an amount in the personal account. March. And where else?
Green one, Lordship.
Where is the annexer, the audit? Is there the annexer 1, 2, 3, 4 is also there? Lana PP?
Yes, no. But I didn't flag it.
You have flagged?
No, not flag, Lordship. That is the statement of their co-worker, Lordship.
Okay, over the years since 2019 to 25, 1 crore plus deficit found from the account. So
Data, my lord, if it is so, my lord, if report I say so, my lord, my humble, my lord, the person who intentionally, my lord,
okay,
in calculative
so he
manner, my lord.
was served as he was working as a salesman only.
On earlier.
But then since 2019,
Yes.
the SN Gupta left job. And then you assume as a manager.
So person who have
The
calculated
post of
manner,
manager since he left.
totally jeopardized my lord, 12 family, my lord. Into now we are in is this a big 12 family, my lord, who was dependent on this, my lord, that if my lord grant bail, my lord, they will send wrong message to society, my lord. The bail cannot be a license, cannot be a license to commit this crime, my lord. So my humble sum, if record is
What company you said? What company?
Consumer Goods.
Huh?
G Consumer Goods.
Consumer goods.
we as much as 12 family, my lord, who is dependent in this whole business, my lord.
Hmm?
12 family, my lord, 12 family, my lord, who are dependent on this business, my lord.
Consumer
Now, due to this
business, consumer goods, which all being salesman. You became a manager after 2019.
What I've been instructed is that
No. Statement revealed that you were a manager of, earlier you were a salesman only, but then since 2019, charge of the manager.
Therefore, my lord, his interim also need to vacate. Interim
so-
was granted
No,
on
no,
those apartment only, my lord.
See, this is a misleading statement that you
Yes,
were
ma'am.
not the manager. The earlier manager who left job in 2019, and then after 2019, you were the manager till 2025. And after 25, again, this person was recalled when you left.
My humble submission, that count alone, my lord, for making wrong statement, my lord, this bail is liable to be dismissed, my lord. Otherwise, my lord, law bail is clear, my lord, in this offense like economic, my lord. I would not say this is total economic, but it is akin to economic offense, my lord, as due to his criminal conduct, my lord, as much as 12 families have been affected, my lord. In such situation, my lord, bail of law is clear, my lord. If there is something prima facie, my lord, in the FIR or in the CD, my lord, the burden shift upon my lord, him to my lord, no, I have not done so, my lord. Until in a death is satisfied by the honorable court, my lord, not grant bail to him, my lord. Privilege of AB, my lord.
No, all these salesmen, the present salesmen, all of them have stated you are manager only.
Yes, ma'am.
And you were also salesman, but then since 2019, you became manager. There was a false statement. It was difficult. You were, that means not properly instructed.
That might be so. That might be so. That might be so, madam. I'm sorry.
You were not properly instructed.
But again,
see, all the evidence goes against you.
Ultimately, the thing is whether my custodial detention is required or not, since I'm cooperating, and it is always open for him to recover the money from me. And he speaks about recovery in the FIR itself.
See, being a manager, you have transferred money in lakhs against your wife, in the account of your wife and the brother. What is their salary? The brother was also working. What is his salary? What was his salary?
I do not represent my brother. My wife is serving as a nurse.
But then you see, in his account, you have transferred lakhs of amount money.
I'm not running away, neither am I shying away from appearing, my lord. In a
It's
trial,
not a question of running away or not, but then the intention that what you have done.
He was unaware.
After, see, transferring this much of amount illegally, when they are not entitled, then you say that I'm not running away.
No, I'll definitely.
You could alone. Then you can say I'm not running away. I'm giving it back. But then this, you see, after a stolen, I'm not running away. Is it okay? How do you justify that?
But he has to prove, my lord, by way of a suit, through evidence, whether I have embezzled money or not.
You did not ask while taking money how he will file suit
What will
against
he,
you.
what will the informant gain from putting me behind bars, Your Lordship? Now he is aware of my whereabouts, he can definitely recover it from me.
That we do not know what he will gain. I don't know whether he
Well,
gets
he's-
satisfaction
he-
or what.
well,
I
he's
don't know.
submitting that.
And at the same time, whatever may be, you are inside or not, but in any case, you have to return only. What is this? This earlier, your brother was also granted. Who, brother or whom? Josna coach is?
Josna is my wife, Your Lordship. Item number 16.
Okay, she is also protected. Okay, similar order was given passed.
Yes, yes.
She is also, what happened to her bail?
Well, she also appeared and bail has been
Thereafter,
arrested
regular,
and
made
arrested.
absolute?
No, Lordship, that is pending. That is item number 16.
Okay,
Lordship.
the same is pending
Yes,
here.
yes.
Okay, so she was granted, that is why similar order was passed.
Yes.
No, madam.
Earlier, he was granted, my lord.
Hmm.
Accordingly, my lord, his benefit are given to his wife, my lord.
Mhm.
Now, my lord has seen, my lord, he was granted based on his false affidavit, my lord. False statement, my lord, he was not manager, my lord, just he a salesman.
Hmm.
So that bail, my lord, will kindly not extended, my lord. He was that a court on the part that he was the only salesman, my lord, not the manager, my lord. That's why he was granted. He was granted benefit of interim, my lord, because only because of his false apartment, my lord, saying that he was just salesman, my lord, not the manager, my lord.
Yes, yes.
Now
No, because I remember earlier he says that he was not a manager.
Yes, my lord.
Then if the person
Only
is not a
then in
manager,
such
there
situation
is
he was
actually
granted
no
AV.
possibility, no chance. Badger or how he
Yes, my
has
lord.
a financial power.
My lord.
But then if he was a manager,
My
he
lord,
has a
now
power.
he himself excuse me, yes, he is manager, my lord. So I humbly submit, my lord, the benefit, my lord, he has got by making false statement, my lord, will be not made absolute, my lord.
What is this? Okay. One 85. The IO probably also did not say whether IO says that on which date the amount was transferred in the name in the account of the wife and
Lordship, record is here, Lordship.
brother.
The-
Can you just find out when it was transferred in the name of the brother and wife? On which date? Because he was since 2019 and then left in the March 2025. Just find out.
On 1st January 2021, Lordship. On 1st January 2021, 20,000 was deposited.
20,000. 1st January
2021, Lordship. 20,000 was deposited.
Again in the account of
In the Padma, the applicant.
Padma is not the employee.
His account, Lordship.
Padma is not the employee of.
He is the manager, Lordship. In his account.
Oh, sorry, Padma.
Yes, Lordship.
He is the accused.
Yes, Lordship.
Sorry.
The manager.
Manager. This must be his salary. How much he gets? How much you got?
In his RD Lordship, RD account, Lordship. 20,000, Lordship.
What was your salary? How much you were drawing?
I'm not instructed.
See, at least that could help. No? 20,000 is nothing, but maybe salary. Just show me some amount which was deposited. Wife is not no. Wife was not working.
No.
Okay. Wife. How much amount was deposited in the account of the wife from the company, not from his own account. And when? Show me just 1, 2 occasion, and in a total, if somewhere it is given, and also in the name of the brother if it goes in lakhs, if not the salary.
On 5th July 2021, 2 lakhs was withdrawn from the account of this GG Consumer Lordship. This company, from the account of company, Lordship.
2 lakhs to whom?
The 2 lakhs was withdrawn from this company's account, Lordship.
Who withdraw? Accused?
Yes, Lordship, accused.
Maybe for some other reason.
All done by the accused, Lordship.
No.
This is the
Yeah, that may be for some other purpose. But you say how many much of account this amount was deposited in the name of wife from the company. He is withdrawn maybe for some other purpose because some of the employees were paid in cash.
Yes,
I don't know why he had to be paid. Or he had paid in case.
It was 50,000. Salary was 50,000.
50. So that may be salary withdrawal, but then transferring amount from the company to the wife, prima facie would show that there was an illegal act. Otherwise, you see, withdrawal, transfer to other account, maybe for business or any other purpose. You have to show prima facie there is a case against the accused that because he has transferred so and so amount. Otherwise, since he is cooperating and appearing before the IO, then his custodial interrogation may not be necessary. Ranging for 6 years. In 6 years, and why at this time or at this moment only he could found out?
Yes, Lordship.
Yearly it will be around 30 lakhs.
On 5th January 2021, 30,000 credited to the account of his wife, Lordship.
Okay, from the company.
Yes, Lordship.
On
On 5/1/2021, Lordship.
No, this is not company. This is Padmabara transferring to his wife. This is
Huh?
from the accused to the wife, not from the company.
No, not from the accused.
Yes.
From the accused to the wife, automatically, why not? That you don't count. From the company to wife,
Yes.
because your allegation is like that. You just show me one or two. Yes, deposit. So the audit was done at one go for 6 years.
Yeah, without doing any lordship.
No, what,
After he
audit,
assuming officer, there was no audit lordship done by the.
no, why you did not do? Why you did not do? You have not been vigilant. Now see, you have to actually identify and figure out how much of amount was illegal, because there is a legal transfer also, so many amount.
Yes, lordship.
If there is illegally, you have to actually figure it out.
Can this method be taken up tomorrow, lordship? So that
You
I
just
can-
figure it out.
Yes.
And then I ask the IO, which are the amount illegally transferred
Yes, lordship.
against the name, in the account of the wife
Yes.
and others. Otherwise, this transfer, you cannot say that
Yes,
these are illegal.
exactly.
These are legal only.
Yes.
During the transaction, during the business, it was done. And then from his own account, transferring amount to wife, we cannot say
Yes.
that is illegal. You want this matter to be taken up
Tomorrow, so that I can figure it out.
tomorrow? Okay, so tomorrow's list already prepared, so day after tomorrow, okay? Let's pray for by the Land Council for that.
Day after tomorrow, I'm from Guwahati, my lord. Day after tomorrow will be a little difficult. Perhaps at the end of the week, Your Worship. Friday.
Friday?
Then Thursday again I can come.
Okay, Thursday then?
Friday, if you love.
No, Thursday will do. Friday would be difficult. Thursday? Or if you can stay tomorrow also, we can.
Tomorrow
take-
I'm ready.
Tomorrow, okay.
Tomorrow
Then
I'm-
tomorrow. Okay, let's pray for by Mr. Lloyd Lanet PP. List is matter again tomorrow. Tomorrow on date, write the date. Okay. Okay. How many matters are there? Hmm? Oh, okay, all of
My lord,
15, 16?
in item number 18, my lord, I am referring on behalf of
Just
the
a minute,
experts.
15, 16 and 7.
My lord,
18 is also?
18 is also out of same, my lord, arising out of same FIR, my lord.
Okay,
My lord, my friend, my lord, I have got the information, my lord, that how the transaction has been. Allegation is some amount has been deposited in my account, my lord.
You
I
are
am innocent.
brother.
Brother.
Okay, let us take up tomorrow.
My lord, my friend, my lord, matter will be listed on 20. In the meantime, my lord, I'll come with the detail affidavit. In my apartment also, I am innocent, my lord. All
Maybe, okay.
My
So,
all transaction has been made by my other brother, who is the bank manager, the manager of the company, my lord. And he has deposited, my lord. I have categorically stated in my
how much amount was deposited?
my lord, amount whatever has been deposited has been withdrawn by himself, my lord, saying that it is the company's amount. So therefore,
Are you also the employee of the company?
I am the salesman, my lord.
Salesman.
And my brother is more smarter than me, my lord.
Okay.
And because of that reason, my lord, the amount has been deposited in my account that has been taken and withdrawn by him for the purpose of, my lord, on the guys.
Entire amount?
Yes, my lord.
You have the
Yes,
record
ma'am.
of
Account.
entire amount?
Yes, yes. The amount, whatever, the amount that has been deposited in my account, well, it has been instantly withdrawn by
You
himself.
have been implicated only because your brother has
Yes.
transferred some amount in your account?
Yes, my lord. And it is
but
not.
the fact is that it has already been withdrawn.
Yes, my lord.
Okay. If you
My lord, I'll come with
to-
affidavit and how the amount was deposited and withdrawn. My lord, I'll come with the affidavit, my lord, additional affidavit.
Please, tomorrow. We'll take up
Tomorrow, my lord, since on 14, my lord, I appear before the IO of the case. I was allowed to sit it for the 2 hours, more than 2 hours, my lord, on the guise of, my lord, recording of the statement. Thereafter, my lord, the IO has not come, and straight away I go back to my hometown at Nagaon, my lord. Now I am in my client is in Assam. My lord, at least 2 days time may be given, my lord. I'll come with the detail affidavit, my lord.
How many days? 2 days.
My lord, on 20, my lord, subject to convenience.
20 is?
20, my lord, is
20 is Friday.
my lord. I'll
Let
come
us
with
make
my.
it Thursday. Friday would be difficult because Friday is the last date. Less case will be
On 19,
listed,
my lord.
and it will
then
be
case,
difficult. Huh?
On 19 or Monday, my lord.
Okay. Huh?
Monday, my lord.
Monday.
Monday, my lord, it is on 19, after 19.
19 is Thursday.
23, my lord. I'll come with detail affidavit, how amount has been transaction, man. It is not known to me, my lord, how amount has been deposited. My lord, it is.
Then in your case,
my lord, I have categorically.
the other case will take up tomorrow then.
My lord, on 23, my lord, I'll come. My case is completely, my lord, separate. How amount has been transaction has been made by my younger brother, my lord. But my lord, that has been withdrawn by him. And it is not the case of the, my lord, the prosecutions, the amount has been.
Present the wife.
My lord.
Okay. Okay. Wife and husband can be taken up tomorrow.
For him, my lord, I'll come with my additional affidavit, my lord. Details of my account, my lord.
Okay.
I've taken out the, my lord, the printout copy from the, my lord, but it is not complete. I instructed them to give the details, my lord. 3 pages, how the amount has been transacted. It is not that case, my lord, that from company, it has been directly transferred in my account. And it is not the case that I have withdrawn, man. Withdraw him, my lord, self-shown, but my lord, along with that withdrawal foil, counterfoil, my lord, I'll show your lordship.
Kindly see whether he stated, because he has given a statement that the accused has the younger brother has deposited and withdrawn by
Well.
himself. Whether in his statement, whether that has come or not. Kindly examine that also.
Yeah.
Huh? Okay. So then in that case, your case will be a separate one.
Yes, madam.
We'll take about
on 23, madam, I'll come. Madam.
If you say that on Thursday, we can fix all the matter on Thursday.
Madam.
Hmm?
Subject to convenience on the part of the other person. They are Guwahati-based lawyer.
Along with the wives, the brothers' statements are also there with Learned PP. So let me take the chance tomorrow and Learned PP can assist the court regarding what my learned friend is submitting, whether the amounts have been deposited.
If it is difficult, then but if it is available, no need to file affidavit also. If the statement is available.
In that has not been furnished to the IO of the case, madam. Is my account statement has to be taken out from my branch.
Because even from the account statement also, nobody can withdraw other than you yourself. It will be self. We do not know who is self.
Since lordship is sitting on till next week, my lord,
Next week I'm not there.
Then
this week also.
My friend is on Friday, my lord. At least
Friday difficult because that will be the last date. Thursday.
My lord.
Take a chance. My learned friend's matter can also be there in the list. If he wants an accommodation, your lordship will maybe he's to grant an accommodation.
My lord.
Tomorrow, what we'll do tomorrow, if your case finds to be a little bit difficult to we find that no, some more you should be given an opportunity, then what we'll do is we'll take up their case and your case will be posted for Monday.
Therefore, my lord,
okay.
Straight away, my lord, my matter may be my lord separated from my lord. I come with my lord. What only what I want to do
tomorrow,
is
tomorrow we'll listen tomorrow and then you'll be accommodated tomorrow.
My lord.
Okay.
Till such time, my lord, that interim, my lord. Till such time, my lord.
The interim all continue.
Yes, my lord. Interim.
All for now, all tomorrow only. Yes. 16, 17, 18. Huh? Tomorrow.
Your Lordship, the counsel for respondent number 1 is today.
Okay. You are for?
Respondent 1.
Lordship, may I pray that the affidavit with regard to service of notice with respondent was taken to substitution matter and published in the Arunachal Times. That has been brought to this notice.
You are for respondent number 1.
Yes, on behalf of the counsel for the respondent 1.
1. Okay, 2 is not being represented. You may publish paper publication.
Yes, it has been done.
File affidavit to that effect.
Yes.
Okay. Mr.
T time.
T
time.
Your name is there?
Yes, Lord.
This is item
19.
Okay, T time. Land counsel for the applicant. He submits that he has taken steps upon the respondent number 2 by paper publication and compliance and file compliance affidavit by annexing the paper publication stuff. Of the notice in the local daily, the Arunachal Times, on 27 May 2025. Staff. However, okay. Seen the paper publication. Seen the affidavit and the paper publication stuff. Paper publication annexure 1 stuff. Where however no one appears on behalf of the respondent number 2 stuff. Mr.
On behalf of Jeetalo, Your Lordship.
You are Mr.
On behalf Jeetalo, on behalf of Jeetalo. Vishal. VT Gurung, Your Lordship.
Write his name, appear on behalf of Mr. G. Talo, Land Counsel for the respondent number 1. Stop, What is this case about?
Lordship, IA 249 is for delay condonation.
You have any objection to the delay?
Lordship,
I'm not aware, Lordship. I'm only on behalf of the conducting council. I'm not aware of it.
How many days? Delay of
102 days.
No problem. Who is this respondent number 2? You are
respondent number 2 is the owner. Yes. I'm the
owner.
Yes, I'm the insurance company.
Your insurance company.
Yes.
And you are not liable according to you.
Lordship, the judgment says that I'm not liable. However, I'm being directed to recover it as a land revenue area.
Yes.
Now the issue is that Lordship, since Lordship, the people here in Arunachal does not pay any land revenue, Lordship. How am I supposed to recover the amount?
The order was passed by which court?
Yes, Lordship.
Order was passed by which tribunal? Or
MSCT Bomdila, Lordship.
Bomdila.
Yes. Now, Lordship, they have filed an execution petition and the divisional...
You are for claimant?
Yes, Your Lordship.
Claimant has no role otherwise. Okay, then we'll pass. Then this is an application filed under Section 5 of the Limitation Act 1963 for condonation of delay of 102 days in filing the connected accompanying appeal. Stop. The ground for delay in preferring the connected appeal has been explained in paragraph. Which paragraph you have stated?
Paragraph 3.
Paragraph 3.
3 to 7, Lordship.
4, 5, 6, and 7. On perusal of the ground stated by the petitioner, seeking condonation of delay, and then 3 to 7, this vote is of the view that the applicant was prevented by sufficient cause for not preferring the connected appeal within the stipulated time. So, para. The learned counsel appearing on behalf of the respondent number 1 has raised no objection.
Your lordship, it may be heard on the next date, your lordship.
It will be your advantage only. The more it will be kept pending, you will be loser.
Your lordship, I believe the conducting counsel has some certain issue to it.
Why he is not appearing? Okay, so despite of serving of notice by paper publication, the respondent number 2 is not appearing. This indicates that he has no objection to the condemnation to the condonation of delay. In condoning the delay in filing the connected appeal. Stop. In view of the above, the delay of 102 days in preferring the connected appeal is hereby condoned. Stop. Whether the appeal has been numbered?
Yes, Lordship.
Okay.
Appeal 21.
Okay. With the above, this IA stands disposed of. Where the appeal has also been listed today.
Yes.
This is item 19. Okay, in appeal then, Then in appeal.
Lordship, there is an IA, another IA.
What is that IA?
That IA is for stay, Lordship.
Then in that case, you have to deposit 50% of the.
Lordship, with the condition that if they withdraw, they file an application before the Honorable.
Okay, then in IA, so no, in appeal, that will see your benefit. He is going to deposit 50%. That will be for your benefit only. Okay, in appeal. Another IA is not in the list. Is it in the list? 21? Yes. Okay, in appeal, Hard Mr. T. Tai, learning counsel for the appellant, insurance company. Stop, para. This is an application file. This is IA appeal. Make appeal. Under section 173 of the Motor Vehicle Act 1988 against the judgment and award dated 2/6/2022 passed by the Motor Accident Claims Tribunal within bracket MSCT bracket close West Coming Bondila in MSCT case number 02/2019. Para. The appeal is admitted. Call for the relevant record. Para. Issue notice. Para. Since Mr. His name, appeared and accepted notice on behalf of the respondent number 1 claimant, no formal notice need be issued to the said respondent. Have you received the copy? You furnished copy?
Lordship, I'll furnish extra copies. I have furnished.
Already furnished?
Yes, I'll furnish extra copies.
Okay. However, the appellant, learned counsel for the appellant shall furnish extra requisite copy to the learned counsel appearing on behalf of the respondent number 1. Stop. Para. The appellant shall also take steps upon the respondent number 2 by a registered post with AD as well as by usual process within a week from today. Stop. List is matter after 4 weeks. Okay, you have, because since the respondent number 2 did not appear in the earlier also, you have to take fresh steps here also. Okay, and in IA, this IA is another IA is 250 and IA 250. part, Mr. Same, Mr. Tita, Land Council for the applicant stroke appellant stuff, para. This is an application filed under order 41, Rule 5 of the Code of Civil Procedure 1908, seeking stay of operation impugn order dated or impugn judgment and award dated 2/6/2022, passed by the Motor Accident Claims Tribunal, Bomdila. Stop para. Since the connected appeal has already been admitted, the operation of the impugn judgment and award dated 2/6/2022, passed by the member Motor Accident Claims Tribunal, Bomdila in MSCT case number 02/2019 shall remain stay, subject to the condition that the appellant deposits 50% of the total awarded amount before the registry of this court within 6 weeks, 4 weeks. 4 weeks. Within 4 weeks from today. Start. Para. They will be allowed to withdraw.
Procedural by filing an application before.
Okay, you file an application for withdrawal.
Okay.
Okay, withdrawal of this 50%. Okay. Okay. Then with the above, this IS stands allowed in. Okay. Yes. Next. What about 22?
Along with item number 12.
Okay, already passed. Yes, yes. Okay, 23. No.
Service report to the private respondent is still awaiting. Service report to the.
Okay, 22. This is criminal petition. Quashing petition.
Yes, sir.
Service upon respondent number 3.
3.
This is on merit. You are challenging.
Yes, yes, Lord.
Okay. The okay, Mr. Omodi, Land Council for the petitioner is present. Miss Jeannie Lanet, additional PP, is also present on behalf of the state respondent number 1 and 2. The service of notice upon, so the service of notice upon the respondent number 3 is still awaited. When will you take the steps upon the respondent?
Well, on next day.
You want, huh?
10.
Okay. In view of the above, list this matter after 2 weeks.
2 weeks. Yeah.
Yes.
I think allowed to introduce.
Okay, this is for withdrawal. I thought could have mentioned in the beginning.
It's okay.
Yes, yes, it's only for withdrawal. So I
Yes.
thought something.
There are some inadvertent errors while inadvertent errors while annexing the documents. We have to withdraw with liberty to file afresh. And as on today, I have not availed the interim order.
Okay, Mr. K. Saxena. Land Council for the petitioner. Tommy said there is some type of error.
Inadvertent errors.
Inadvertent error in the application. Therefore, pray for allowing him. And therefore, he wants to withdraw this bail application, bail application, liberty to file afresh. Stuff.
Interim is vacated.
This AB, and this application stands, application is dismissed on withdrawal with liberty as prayed for, comma. Stop, huh? The interim order passed
11/6.
On 11/6/2025 stands vacated.
Obliged.
Okay.
Obliged.
Okay. Let me, his presence also, huh, in the second line, before the ending, okay. Mr. T. Line council, line additional PP is also present. Okay. Stand, okay.